to specific groups, asking them to comment. For today's meeting, we have invited, as agreed at our February 11th meeting, the Shipping Association of Jamaica, the Custom Brokers Association, the Airports Authority, and the Montego Bay Airport Authority to present their comments on the bill, and the agenda has that as the substantive activity from today. However, before we get there, just want to know if there are any apologies for absence. No, Senator Hill is here. Okay, no apologies for absence. The minutes of the meeting held on Thursday, February 11th are before us. Are there any amendments to those minutes? If there are no amendments, can I have a proposal that the minutes be adopted? Moved by Senator Hill, seconded by Member Malahoo Fort. Thank you. I don't believe there are any matters arising from the minutes. I went through some of the things that we agreed, and they have been acted upon, inclusive of the notice placed in the paper and writing to specific stakeholder groups. So with your agreement, I propose to move to the segment of the meeting where we hear from specific stakeholders who have written to the Joint Select Committee, and I believe the first on the agenda is the Airports Authority of Jamaica. Can we call them in? The Airports Authority of Jamaica.
While we are awaiting the entry of the presenters, may I ask for your kind consideration that we, for future meetings, consider a mixed forum, virtual, along with, to enable persons who have not yet been vaccinated or who may have to be in quarantine to also participate.
So are you, moving, we could move completely virtual?
We can do completely, or we can do it mixed.
If we did mixed, where would they be projected?
The parliamentary staff, we have other committees that operate like that.
That operate, and you have the screen in front of you?
Sorry, good afternoon. I don't believe any committees have successfully had a mixed you can correct me, Ms. Bailey, but we haven't successfully done mixed, because as far as I understand, our technical capabilities as they are right now, we cannot facilitate the interactions from people in the house with the people if it is mixed. So it's mostly fully in person, or fully in person, fully virtual at the moment.
So would would the members of the committee have a problem if we had fully virtual meetings? Yeah, it's practical, right? All right, I'm hearing that that would be supported by members of the committee. So for the next meeting and the ones after, we can have fully virtual to accommodate all the people who need to attend and those who are in quarantine.
Chairman, at least when we're doing the presentations, because that would be useful. And then if need be, certainly during those meetings when the presentations are being done, and then we could reconsider when we have to do the clause-by-clause assessment. Right,
when we get to clause-by-clause. So for the presentations, we will have virtual. Okay. Okay, Airports Authority, welcome to the Joint Select Committee meeting, considering the act to replace the Customs Act. Can you just introduce yourself? And then I'd ask you to begin your presentation. Can you come forward? It'd be better if we can see you. Yes, right here. Yeah, sorry about that. So if you could just introduce yourself and then begin your presentation. Just bring a mic and press the button to turn the mic on.
Hello, good afternoon. Good afternoon.
Afternoon.
Good afternoon, Chairman, and other members of the committee, and also the technical working group. The Airports Authority of Jamaica appreciates the opportunity to appear before you this afternoon. Just to advise you about the Airports Authority of Jamaica. The Airports Authority of Jamaica is a body corporate established under and by virtue of the Airports Authority Act of 1974, and it has statutory responsibility for the administration, control, apologies, Chairman. I should introduce myself before I start to speak. So I'm Verona Vassiano, General Counsel of the Airports Authority of Jamaica. And with me are Ms. Nicole Berger, PAC Kingston Airport Limited, operator of the Norman Manley International Airport. Also with me are Kerry Cannon, she's the legal officer of the AAJ. And with me around back here, Mr. Peter Hall. He's the head of security at MBJ Airports Limited, the operator of Sangster International Airport.
I see. So you're coming as a group, Airports Authority, along with the operators.
Right.
Well, welcome to the Houses of Parliament, and we look forward to hearing your presentation.
Thank you very much.
And you see your name tags have been prepared for you. Okay?
Thank you, Chairman, Mr. Chairman. So the Airports Authority of Jamaica is a body corporate established pursuant to the Airports Authority Act of 1974. We have statutory responsibility for the management, control, and administration of prescribed airports in Jamaica. There are 6 prescribed airports in Jamaica: Norman Manley International Airport, Sangster International Airport, Tinston Penn Aerodrome, Ken Jones Aerodrome, Ian Fleming International Aerodrome, and Negril Aerodrome. However, currently, we only manage and operate 4 of those prescribed airports. The other 2 were concessioned and are now operated by private operators. And as I said earlier, Norman Manley International Airport is operated by PAC Kingston Airport Limited, a private operator, and SIA by MBJ Airports Limited, a private operator. Moving on. So following the AAJ's written submission on the subject matter, we now submit our comments for consideration. With respect to Section 22, subsection 2A of the proposed Customs Act, subsection 2A, we note that the proposed act is silent on the issue of cross-gender search. For example, in the event that a female is allowed to search a male, that male may refuse to be searched on religious grounds. Based on the current wording, it says that with respect to in section 222, subsection 2A, it states that a female shall only be searched by a female officer, right? So it is implied there that maybe a male could be searched by a male, or a male be searched by a female. It only speaks about the same sex in relation to the female gender. So we're saying that it could be that a male may refuse to be searched on religious ground, and may successfully assert that his constitutional rights to his religious belief is being infringed. And this recommendation emanates out of an experience or an incident which occurred at one of our international airports, wherein the passenger objected to refuse to be searched by a female. This gentleman was a practicing Judeo-Christian, an Orthodox Jew. And during a certain period within the Jewish calendar, I think it's called Negaya, they are not to be touched by a female. And he objected to be searched. However, he indicated that he had no problem whatsoever to being physically searched, but that he had religious grounds that caused him only to permit a physical search by a male if only hands were to be used. So it's on this basis that we are making a recommendation that an option should be included in this section, proposed section 222, subsection 2A, for the traveling public to have an option to request that the search be conducted by someone of the same gender or the opposite gender.
Okay, I mean, I think you've made a reasonable point. I believe we could, Commissioner, you want to?
Yes, Minister, good afternoon. Well, based on the information just presented, I think the concern is noted and we can look into it further, Minister. Yes. All
right, can you proceed?
Right, and we have a suggested wording, Commissioner, for in terms of the proposal that we're making, our recommendation. We have the proposed language that could be inserted in the bill. So I could share that with you. Yes.
May I just, the point, I believe, raises two issues.
Yes.
One, in relation to what is prescribed at clause 2A of female-to-female search.
Right.
But you also spoke to an objection to a search on religious grounds.
Religious grounds.
So constitutionally, what the guarantee is in relation to arbitrary search. The words in the opening 22.1, where there are reasonable grounds to suspect.
Yes.
So the reasonable grounds for suspicion is the antidote to an arbitrary search.
Right.
And arbitrariness generally.
Right.
So just to...
Right. The final point that I'll make from AAJ's perspective, the operators, of course, will make their submission because, as I said before, at the top of my statement, that we no longer operate these two international airports. So the AAJ has concession oversight for the operators. So this last point, the second point, which is an extension of the first point, is that the AAJ notes that the Customs Act, the proposed act, of course, does not prescribe the methodology to be utilized by the person undertaking the search. And this is more so in light of my comments about the cross-gender search, in terms of a physical pat-down, physical search of the person. So will the custom officer utilize aids such as imaging equipment, mechanical devices, electronic devices such as an electronic paddle if a cross-gender search is being undertaken with a female when she is conducting that search of the male? You use an electronic, a paddle in order not to, for the person to feel as if their person is being trespassed upon.
I may through you. So the section dealing with searches are not new to the jurisprudence, as you know, Counsel. This is in relation to the suspicion that a person is carrying goods that are subject to customs control and in respect of which a contravention of any custom law is being committed. That is the context in which the search is permitted. The point you make, the previous point is one that is valid and will be considered. But again, in relation to the person, operators of the airport would know more. I've only seen it from the court side sometimes where contrabands are hidden. So if the object of the section, upon having reasonable suspicion that goods that are, they're carrying goods that are in contravention of the law, then the suspicion, of course, the person is entitled to be told. But as to say how you're going to prescribe it, it's another matter, but the team will look at it. Because searches are not something that are new, they're not unique to any law. But the context in this case contraband can be hidden in any of many places. It can be exposed, and it can also be hidden internally, and we have case law dealing with that too.
Very well, Madam AG. Thanks for the guidance. Mr. Chairman, well, that completes the AAJ's contribution. So I'm going to just hand over to Ms. Nicole Berger. She's from the PAC Kingston Airport Limited, the operator of Norman Manley International Airport.
Okay, welcome, Ms. Berger.
Good afternoon. Thank you, Chairman. Good afternoon, members. We were invited, and we did submit written submissions as well to the committee chair. I don't know whether members have had the opportunity to view it, but I can go through. Our submissions, I'm afraid, are a bit lengthier than those of the AAJ, but I believe that having had the opportunity of seeing the comments also of MBJ, I do know there is a fair amount of overlap between what the two the operators have to say about the act. So, Chairman, I know Ms. Vassiana has handed over to me, but I do know that my colleague from MBJ is hoping to go back to Montego Bay this afternoon. So perhaps, Chair, if the Chair would like to invite him to precede me, I would yield to him.
Please go ahead. If you have a time constraint.
And Chair, just before she starts, I haven't seen a copy of that report. I wonder if the parliamentary staff have it somewhere for distribution. But please go ahead. We can work that out. I'd love to get a copy.
Thank you. If I could start first, Chairman, with a general comment, and that is that the Act appears to give the Minister with responsibility for customs and the Customs Commissioner very broad, if not unfettered, powers to designate not only which facilities may be utilized as a customs-controlled airport, but also the areas within the designated airport which should be used for customs processing. In the context of the international airport, the customs functions occur within the boundaries of the airport plant, which houses a number of necessary and regulated functions and the facilitation of civil aviation generally. The bill does not, in our view, take sufficient cognizance of the fact that the customs functions are occurring within the broader context and that many factors go into the design, development, and the overall operation of the international airport. For example, the planning of airport terminal development is usually done on the basis of international service standards, taking into account passenger volumes, queuing times, processing times, rationalizing passenger movements and flow throughout the terminal. These developments are of necessity highly capital intensive and planned with long-term planning horizons. Changes in the layout of the airport operations are not easily accommodated and may be very expensive to implement and should be done following consultation with stakeholders. So that's sort of if I could sort of indicate the general context of our main comments. To specific comments now, Section 29(1)A, which refers to the appointment of areas as custom-controlled airports. The power of the minister to appoint any area within an airport as a customs-controlled airport seems to be unfettered even by a requirement for consultation. There are many factors which go into the design and layout of the airport, and the need for customs operations is only one of them. The airport must also be concerned about passenger flows, safety, security considerations, fire safety, queuing requirements, international standards, and service quality considerations in making decisions as to the location of such areas within the airport. Section 29(1)B, the power of the minister to alter the boundaries of any customs-controlled airport. This also appears to be a very broad and far-reaching power, the application of which is uncertain. As an airport operator, the issue of concern is that altering the boundaries could have significant capital expenditure impacts for us, even while there is no process for consultation before the minister arrives at such a decision. Section 29(2)A, access to customs officers at all times. The section provides that the operator of a customs-controlled airport, and on our reading, the airport operators would fall within the definition as it is in the bill currently. So the issue of the methodology for granting of access to customs officers. So there are, Chair and your members may understand that the airports have essentially different kinds of zones. Some are security restricted zones, there are restricted areas, there are public areas. We designate between what is known as the land side of the airport and the air side of the airport, and persons generally require a specific reason to be allowed access to any particular restricted area of the airport, the reasons having to do with their function, why they are at the airport and why do they need access. And so typically the customs officers who are assigned to the airport do have access to restricted areas for the purpose of carrying out their functions. So we just want to ensure that there is no conflict between regular security provisions and the granting of access to customs officers to any other areas of the airport, and also officers at all times to enter a custom-controlled airport. So currently, I believe the customs agency would issue to its officers its own identification for that purpose. And then we have customs officers who are assigned routine duties at the international airports, and those persons typically also are issued an identification for the airport, from the airport operator. However, there are times when customs may have functions. They have some special teams that sometimes visit the airports who are not persons who are ordinarily working at the airport, but they may come there for different purposes. And there has been, at times, I think a little lack of clarity between how those officers who are not routinely assigned at the airport should be given access to restricted areas of the airport. So we just want to ensure that there is no conflicts between the different kinds of security requirements that the airport operates under and the Customs Act. With respect to Section 29(2)(b,
just for clarity,
yes,
my understanding is that the nature of the customs work in controlled areas is really to enable the custom to ensure that contrabands are not, one of the reasons that contrabands are not hidden in places that they can't detect, they can't reach, they don't have access to. As I'm understanding, and I'm trying to understand the distinction you're drawing between the security concerns of the operator and the functions, the enforcement functions of customs, and how that there may be tension is true, but is it that you're asking for an exclusion zone, or are you asking for a particular approach or methodology to be able to access those areas? I'm not clear what you're asking for.
I think the issue is one of methodology, member, if I may, through your chair. And I believe the issue arises mainly for customs officers who don't actually work at the airport, but may have to come to the airport for. There are some special teams, for instance, I think you have a contraband team and some officers who are involved in some other types of operations who don't necessarily work at the airport, or who are not necessarily stationed at the airport, and who would therefore have been issued with an airport pass per se, as distinct from their customs officer identification. You follow me?
My understanding is that in the discharge of the commissioners Commissioner of Customs responsibility. She can assign or designate officers to carry out particular function. Are you saying that the officers can only discharge that in some areas only if they have a pass from the airport operator?
If I through you, Chair, I think this is precisely the area where the tension exists. Member, that for the persons who are assigned their regular duties at the airports, they would have also been issued with an airport restricted area pass, which is distinct from the identification or the pass issued by the customs agency. But there are times when customs officers who are not stationed at the airport would have to come to the airport in order to assist with carrying out certain duties, whether contraband intervention, interception, and investigation, and so on and so forth. And so there has been a bit about a lack of clarity around, do these officers require to be also passed by the airport and issued with an airport pass as distinct from what is issued by the customs agency. And that's we just want to ensure that there is clarity. And
yeah, let me just comment broadly, and I think it's for the discussion to continue, but it seems to me that given the overriding nature of the work that customs has, not only in border protection, but to ensure that contrabands are not hidden in all different kind of ways, that just as it is in policing, general policing, I don't know that we can be saying to the airport operator that you have the right to say to the customs, you can't access this area, and if you do, it's only under these conditions that we stipulate. I think that the customs, while there is need for prior consultation, there may be operations where the customs don't want to advise the operator that it is doing an operation. And therefore, and I don't think you should be saying to them, we can allow for you to say to them, unless you have a permission, you can't access these areas at these times. So I think there has to be some further discussion around that and some clarity, but generally the powers, as I understand them, would be compromised of the custom to carry out that overriding duty if it has to go through these and get the prior consent of the operator to work in certain areas or to carry out certain activities. That's just my concern generally.
Chairman, I believe more than one things have been said. The first part of the concern, if I'm understanding it correctly, is that the provision at clause 29, as worded, may end up with the exercise of power without sufficient regard to how an airport has already been laid out. So you wonder, there is fear that in exercising the power to designate areas as custom control, you may have a total ripping out and turning upside down of a space that is already allocated in accordance with use.
That is correct, Madam.
I can understand the fear, but I would take the liberty on behalf of the Minister to say, perish the thought. It is not the intention to disrupt. There is an understanding that space is allocated in a particular way. So it's not that an area that is a shop or something else, we're going to say, out with it. But at the same time, as Member Hilton has said, there are certain activities that are carried out within the ports that require access. So the thrust of the proposed new law is to make life simpler and understood, and to take away a lot of the unexpectedness. So I do believe that between customs and the minister, when those when the law is being operationalized, if what currently exists makes sense, it may be kept. If it has to be changed, but certainly the work would be carried out in consultation with the players who have to be there while ensuring that the powers can be properly exercised.
If I may, Chairman, just to indicate what we're in on this point, the issue that we see is that the Customs Act and the legal framework of customs and what customs is required to do in terms of border control is not the only regulatory framework that is applicable, and this is the issue, because the issue of the pass by the airport is governed under the civil aviation regulations and the security program, which is also a regulatory framework. And so what we want to avoid is the clash or the tension between the operation of one regulatory framework and this regulatory framework. Because the airport is a heavily regulated sector, and we're regulated not primarily by the Customs Act, but primarily under the civil aviation regulations, the International Civil Aviation Organization standards and regulated practices. And so we have obligations, we have other regulatory obligations that we don't want to be in breach of in order to facilitate the customs officers under the customs bill. So I think succinctly that is just to ensure that there is unity and
Commissioner?
Yes, thank you, Minister. Burgess? Berger, Ms. Berger. So we appreciate the submission made in the context where you would have indicated that the Minister and the Commissioner would seemingly have unfettered or wide reach. And that is indeed so and should be so as a consequence of being a customs control area, as is the intention. Now, again, because it's a customs control area, you would expect that the customs officer should be able to do their duties without any restriction. And so the intent is to ensure that we have unfettered access for the customs control space. You would have mentioned members of customs who would have been working at the airport, and you mentioned the team, the contraband enforcement team. And having heard that, it says to me that the Jamaica Customs Agency needs to do some sensitization to the airport authority and as well as the concessionaires at both airports, if it is the view for them to understand more our role. We don't intend to have any conflicts with any of the other regulations, and I may say that I have never heard of any conflict in the space between the different regulations that guide us. We would hope that you can appreciate our role and to ensure that as it relates to border protection especially, that our role is very much needed. Now, we are in charge of the cargo that goes in this space, we are in charge of the passengers that goes in this space, and the physical environment, and so should not be restricted. We have our own customs ID, and due to certain regulation that came up some time ago, we were asked to utilize the airport, the individual airport IDs. We recognize that that too creates a restriction, because what it technically does is forces my hand as the head of entity in how I detail my team, because the team will not be able to get access without having your ID, and that then makes you having control over how customs deploys its resources. And that needs to be looked into, because the customs ID in a customs control space should really be the only ID that is necessary. But we would have worked with you over the years, and we will continue to work, because we have dual functions in some aspect of how we work, and we expect that with further consultation, we will definitely work through the issues. But I want you to appreciate especially the role of the Jamaica Customs Agency.
My sense and the conversation, the exchange has gone along the line that I would expect and the concern expressed from custom. But so the two main pieces of legislation, I would think, that comes together in the airport, and I said two because the general policing activity and the customs almost one and the same from an enforcement point of view. And so the other piece of legislation is really the civil aviation regulation. But just permit me to say, it seems to me that the civil aviation regulation is primarily concerned with safety. Yeah? While the custom, I said primarily, if there are areas where it differs, you may want to illuminate. But the customs really protects the sovereignty of the state, the inviolability of the state's role and function. The customs discharges that at the border. And you have to agree that the airport is a border of entry and exit. So it seems to me, Chairman, that, and AG, that if there's a clash, the customs have to prevail to keep maintaining the integrity of the state and its operation. So I would just say those kinds of principles and the clarity that I think is needed would guide the commissioner and the airport's operator in understanding their respective, well, and I'd have to include the airport, the civil aviation authority as well.
I think I agree with Member Hilton. I think the takeaway from my understanding of the concern is that there are other regulators that operate in the space, and you're asking that care be taken to ensure that in the exercise of the functions under the Customs Act, you are not put at risk of being in breach of the other law that you also would have to be in compliance with. Right. And at the same time, from the side of customs, is also to ask you to appreciate that notwithstanding, then there is a bigger function that has to be carried out by customs. But I do not see it as a matter that would detain us. The whole purpose of the exercise is to come to a better understanding, because after all, we wouldn't want our airports to be not in compliance with the Civil Aviation Authority regulations, nor would we want it to be a space that the border is not properly controlled and safely so.
All right, thank you. That was a fulsome discussion. We have more to do when we go clause by clause, but for the time being, I'll ask you to move on to the other section of your comments.
Thank you, Chairman. Just briefly, under section 29(2)(b), the records, the section requires the airport operator to keep records. We're just indicating that we're unable to assess the potential impact because we're not sure what. There are no rules with the bill, so we don't know what kind of records the airport operator may be asked for. 29(3).
Sorry, Ms. Berger, just to say that if you note the words following, particulars as may be prescribed by rules.
Yes.
So the thrust of this new law is to have rules prescribed, forms in place, so no one is taken by surprise as to what the requirements are, and that part of the work is in progress.
Thank you. 29(3), just a small matter. It gives a definition for airport as assigned under the Civil Aviation Act. That act, in fact, uses the term aerodrome and not airport.
Sorry, just a comment from Senator Crawford.
Nicole Berger. Berger.
Yes, Chairman, sorry about that. I heard Mrs. Berger speak to what may be asked for, and I think her concern from a business aspect is a difficulty to curate such information, and by extension, simply saying that it's being worked on, I think she might want to have some dialogue or some input into what is reasonable and the timeline upon which it can be requested, because it could become very difficult to to abide by those rules. So at least I believe that some commitment should be made that interaction will be between them for the information and the timeliness upon which it is requested.
No, thank you for that input, Senator Crawford. The rules and regulations that will be a companion to this bill will go through a similar process, i.e. we'll have stakeholder comment before we enact them. But just bear in mind the context in which this bill is being promulgated. The context is one where Jamaica for decades have had huge problems with our borders, with our seaports, with our airports. The crime that we experience, a large part of it is related to our borders. And what we need are best-in-class regulatory regime with rules in place that's transparent and open, but that allows for proper border control and for the information to be kept so that if you find something later, you can track it down and people can be, right? Please continue.
Thank you, Chairman. I could indicate that I believe members have a copy of the comments now. Yes, the issues with relation to 31C and 31 and 32 are similar to what have already been discussed, so I wouldn't take much time over those. Just section 34, responsibility for goods unloaded from a means of transport. I don't believe that it is the intention. However, as worded, it could imply that the airport operator rather than the airline or the air carrier would be responsible for the custody of goods removed from the aircraft while they remain in a customs controlled
No, I think what they're saying is the goods that are unloaded in a customs controlled area and have not been deposited into a temporary storage or a warehouse are the responsibility of the operator. Because remember, the customs controlled area is an area that's designated as secure. The airport authority, the airport operator is managing entire premises. No one has access to that area apart from customs. So we couldn't hold the importer liable for the goods in the custom controls area. What we're just saying is that the goods cannot, if the goods disappear, it is the responsibility of the operator.
I follow you, Chairman. I believe with the way that the airports are laid out, certainly I can speak for Norman Manley. There are, for instance, there are different cargo warehouses at the airport which are under the control of persons other than the airport operator. So for instance, Caribbean Airlines has a cargo warehouse. So if they bring cargo in, which are uncleared goods, from the airside into their cargo warehouse, it is not the operator of the airport who has control of those goods. It is the...
Understood. Understood. So the comment is that if the goods have not been deposited in a temporary storage facility, so there may need to be an amendment to this to take account of your concern.
Yeah. That the language is just sufficiently broad.
It's too broad.
That
yeah.
it
needs to say if it's a custom control area that's not. We understand what you're saying, and I think that that's a good point. Clause 34.
That is in regard to 34. 35, section 35, I believe, is the operator of a customs controlled area shall provide free of charge such facilities as that customs controlled areas may be specified by the commissioner. This was another one, Chairman, that we understand or we think could have significant financial implications for the airport operators in that it is very broadly stated, and the provision of facilities may be, as it is now, facilities are provided for customs, immigration, and other government of Jamaica entities at both international airports, which are provided on the basis of the necessity of those functions being carried out at an international airport, and which the airport operators do not charge the government agencies for. However, I think this also, Chairman, speaks to the manner in which the airport, the definition of the operator is very broad, and it could suggest that the airport operator, which itself is not involved in the importation of goods or the treatment, so to speak, of cargo, but those functions are carried out by other persons, as to whether it would be appropriate for the airport operator to be required to provide some of these facilities. With respect to...
So on those, I mean, I think we could tighten the language a little bit. I mean, the thrust of it, the principles probably remain the same, but for example, in section 2, rather than saying provide the commission with such office space and other accommodation, weights and scales, we could make it clear that as are necessary for the conduct of, right? So that it reduces any room for arbitrariness.
Yes, I think that is the thrust of the argument, Chairman, that we want to be able to plan with certainty in terms of what it is that is to be provided. As you know, these concession agreements are very carefully structured business arrangements that look very neatly and finely at the return on investment and the capex and all. So we want it to be clear what is the nature of the obligation that the airport operators are being.
Understood. I think there's room here to not lose the essence of this, but to remove the risk of arbitrariness, right? So, point taken there. If the committee will agree, when we're going through clause by clause, we can address it.
May I ask something, Minister?
Please do.
Sure.
I'm going to step out for about 5 to 10 minutes. I don't know if Member Malu Fort, you can step in for me when I'm out.
Ms. Berger, is it that the concept of the concession allows for tenants? Is it that you're of the view that it is the tenants who should provide these fixtures, fittings, and whatever accommodation required by customs in the custom control space? In the context of what you said, that it is using the word operator is broad. I'm just trying to understand.
All right. If I could sort of explain what happens now, I think it can elucidate the matter. There are a number of tenants of the airport who operate whether aircraft or cargo businesses, etc., that have cargo facilities at the airport. There are several cargo importers, and there are several different warehouses, each of which is tenanted to the cargo operator. Within the demise of those areas, there is typically a section for customs. So at the Norman Airport, there are several designated spaces that operate as custom control areas. So each of these cargo warehouses, for instance, we have a whole section of the airport that is the cargo finger, and we also have the cargo village. So if Caribbean Airlines, if AJAS, if Airways, if any of these operators who are in the business of importing cargo, they provide within their space that they have rented from the airport an area for customs activities to be done. And so it is the operator of that warehouse, as distinct from the operator of the airport, who provides the facilities to the customs within their demised space. So what we want to clarify or understand is whether the contemplation is that if the airport is going to rent a warehouse to airline X or cargo operator X, which requires customs activities to be done within that warehouse, whether it is thought that it should be the airport operator rather than the cargo operator who should be responsible for providing what is required for customs to do to facilitate the business of the cargo operator, because it's really the cargo operator's business that is being facilitated by the customs.
Go ahead, Member Hilton.
It seems to me, first of all, I mean, the language is broad, admittedly, but there are ways to to address the particular concern. One of them is just simply through the concessionary arrangement between you as the overall concessionaire and your sub-concessionaire. If the duty devolves on you and you say to the warehouse operator, Caribbean Airlines, for example, we have this responsibility, you have a warehouse, we have a responsibility to provide space for customs from which they'll operate. Then, in the first instance, you could discharge, that responsibility is discharged in part with the sub-concessionaire agreement. But it seems to me always that, well, we're not starting from scratch. So you'd have to believe that there's a modus in terms of how we've operated in the past. And I don't think the Act here precludes an understanding of operator as to the operator of the space, the particular space in the case of Caribbean Airlines warehouse. It could apply. But for clarity, the rules can address those. I think the subsidiary rules, the regulation, can provide some clarity based upon further consultation between the airport operator and the customs.
If I am understanding the concern that has been raised, is that space is premium at the airport and commercial arrangements are such as to maximize profit, and where space has to be made available free of charge, then you wouldn't want to have to give up or alter substantially and detrimentally the allocation of the space to customs. Is that a fair understanding of the concern?
That is a fair understanding, Madam Chair. And also, it is a live issue, member. Unfortunately, with the existing arrangement, which are, as I have described, where there are distinct warehouses and where the spaces that are occupied by customs, and the AAJ may have memory of this, but certainly we have found that in our operations that where the facilities that have been provided by those operators are not what we would like to have our customs officers in, it is sometimes felt, and we have been approached as the airport operator, that as the airport operator, we should do something about the conditions within the warehouses that have been tenanted, that are tenanted out. So there is operationally, there has been a bit of tension.
That the new law is going to change a lot of things as to how warehouses are operated. I see Ms. Edwards raising her hand.
Yes.
Go ahead.
Thank you. I wanted to just provide some clarity. When a warehouse has been designated, it is itself a customs controlled area. And the warehouse keeper...
Where designated is itself a customs controlled area.
Yes. And so the warehouse keeper is the operator of that particular discrete customs control area and would have responsibility for that. The areas that remain under the control of the airport operators such as PACAL or MBJ, the arrangements between customs and you will be governed by the service level agreements that we have always had in place. And those agreements are negotiated for set terms, and we agree as to the specific space that is being provided, the specific type of infrastructure that is required in order to allow the space to function effectively. Obviously, it will not be possible to decide or to fix in stone, as it were, what those facilities need to be indefinitely, because we're always looking to modernize and to make our spaces more efficient. So, for example, service level agreements that would have been negotiated 10 years ago would not have contained any provisions to deal with electronic notice boards, right, for passengers. But today, if we're looking at service level agreements, that is something that we would be negotiating. But the arrangements in terms of the facilities that the airport operator needs to provide to customs, those are negotiated and have always been negotiated and agreed in service level agreements. And so far as spaces are rented out and warehouses are established under the control of Caribbean Airlines or any other operator, that operator is responsible for providing the relevant facilities within that particular space.
Thank you, Ms. Edwards. Just to say that I think some of the fear stems from the fact that the law may be operationalized at a time when your agreements, your service agreements are already in place and they require some changes. Well, you know, like I say, this new law is intended to make life better, not more difficult. And as in all relationships, dialogue, communication, understanding will be required. And that is the spirit in which the entire framework has proceeded and will proceed so far. But be assured that all valid points will be considered and are appreciated.
I think I can conclude with, with a note on Section 51 and Section 263, which again address the issue of provision of information to customs, just that we are not at this point certain of what exactly would be required of the airport operator in terms of the provision of that information. So Section 51 seeks to provide customs on information, reporting on the arrival and departure of aircraft, and the failure to report has been made a criminal offense. And as well, Section 263, which speaks to the records of customs business, and which would require the airport operator to keep records. Again, we just want to understand what is the intention, what kinds of records, because the airport operator, I think in a sense, the airport operator, we are not really involved in the business of importing or exporting of anything, and so the intent of us keeping records for customs, it's not so clear to us. Thank you very much, Madam Chair, and your members.
Just to point out that because the scheme of the law, again, is to move away from people being taken by surprise or a high level of subjectivity, we're providing for information that is to be supplied or information being requested would be known, forms would be prescribed for them. But Madam Commissioner or Ms. Edwards, can you respond to the kind of information that clause is seeking at this stage, or you would want to wait until later in the discussion?
Yes, I think if we look at the provision carefully. Can't hear?
Clause 50.
All right, Clause 51.
Yes.
If we look at the provision carefully, we will, I think perhaps the concern may be alleviated somewhat. 51 provides that the operator of the port or other customs control must provide information as to the arrival or departure of the vessel. That is, the airport operator would be required to say, Caribbean Airlines flight XY arrived at, for example, NMIA.
That's in keeping with their civil aviation requirements.
Exactly. So it is not requiring information about importing or exporting of goods. It's recognizing that the operator has control of a space, and the operator can say what means of transport entered the space and what means of transport exited the space.
Just to say, so 51.1 provides that the operator of the customs controlled port or other customs controlled area at which a vessel or aircraft arrives or depart, as the case may be, shall report to the Commissioner the fact of the arrival into and the fact of the departure from Jamaica of the vessel or aircraft, and an operator who contravenes this section commits an offense. So in this clause, what is required to be reported, I believe, is clear.
Mm-hmm. Yes,
in this
agree.
clause.
I would agree with that.
Yes.
My point in terms of what was required was really in relation to Section 263, which speaks about the keeping of records, which says, unless exempted by rules, every person who conducts business as, and one of the things is airport manager, shall keep or cause to be kept documents, but it's not clear what kind of documents. That is correct, Madam. It appears at the foot of page 171.
Unless exempted by rules, every person who conducts business as a declarant, an importer, exporter, customs broker, carrier, cargo aggregator, operator of a customs controlled area, warehouse keeper, airport manager, port manager, person concerned with the coasting trade, agent or other person who conducts business under any customs law shall keep or cause to be kept in Jamaica in such form and manner as may be prescribed by rules all documents relating to the transaction of that business for a period of 7 years from the date of the particular transaction and make them available as required under subsection 2. That is where you say there is lack of clarity?
What I'm saying, Madam, if I may, is that because the airport operator as an operator is really not involved in customs transactions per se, that is what introduces for us.
But do you conduct business as a declarant? Because that is what it relates to. The airport operator conducts business as a declarant under the Customs Act?
As an airport, as an airport manager, which is one of the named types of persons who should keep the records.
But the section is targeted as the category of persons who conduct business as a declarant.
Very well.
Yes.
Thank you, ma'am. That is all.
You're finished already, Ms. Berger?
I am.
Thank you so much for your very useful submission.
Thank you.
Yes. Mr. Hall, we're going to keep you here in Kingston today, not sending you back to Mobile. Please proceed. Quite muffled, so you may have to adjust your mask somehow. I'm not saying take it off, just adjust.
Good afternoon, Madam Chair, other members of the committee, and members of the technical working group. We certainly thank and appreciate the privilege to have been able to make submission regarding the revised Customs Act. We submitted a couple of concerns that we had, given the language in which the revised act was presented, some of which have already been properly ventilated, and so I will just read and won't belabor the point that has already been made, given the clarification.
There is a point that has not already been made. You could focus your attention there. But don't wish to cut you at all. We want to hear what you have to say, but just in the interest of time.
In the interest of time, Madam Chair. The first point we had was concerned section 29(1), and that was properly clarified by the chairman. Having regard to the minister, may order published in the Gazette upon any area in Jamaica constituting or within an airport as a customs control airport, alter the boundaries of any customs control airport, and impose condition on use of any area as a customs control area. And I believe that the point was properly clarified.
Very well. Noted.
Section 30(1)(a), any place authorized place for loading or unloading of any class or description of goods herein referred to as approved wharf, any place within the customs control port of customs control airport as an authorized place for the embarkation and disembarkation of travelers. Our comment, Madam Chair, is that this section requires further clarity considering the operational priorities of the airport and its land use plan as approved by the regulator. Additionally, MBJ suggests that there should be a level of consultation taking into consideration the safety and operational efficiency in keeping with the global and industry standards.
From Ms. Vassiano's opening comment, yes, that the common concern of, yes, the Airports Authority and the operators is whether there will be consultation to ensure that the designations are done with minimal disruption. Yeah?
Yes, yes, madam. Section 31, 1 and 2, and the point was already raised having regard to access of customs personnel, customs officers to the customs control area. And MBJ's comments that this section requires clarity as the phrase any means is left up to interpretation of customs officer and could facilitate rank abuse of authority without due regards for other protocols, regulation, and Jamaica's international obligation to ICAO as set out in the Civil Aviation Act and associated regulations. Consideration should be given for likely negative impact which could result or prove inimical to the interests of the broader collaborative and collective approach to border security.
If I were to say that where there is a request for access to an area, or where a request for access to an area may impact safety and security, that is where your primary concern is?
That is where
right.
Primary concern is
right.
because, Madam Chair, the Civil Aviation Regulation has already set out in an annex the requirement or how control authority personnel of customs at the top of the list access the airport under the conditions and so that they access the airport. And that document is pretty clear, and the airport must abide by this stipulation from the Civil Aviation.
So I think the point is understood by custom, and
yes.
Based on what Madam Commissioner had said, would want the operators to also understand, because new laws will affect, we can't pass something new and expect to remain in the same place.
Yes.
There will have to be necessary shifts. But point is noted.
Yes, Madam Chair. And this is not lost on us. We do understand the nature of customs operations at airport and the other areas for which they have responsibility. And we do support those efforts in border control and border security. And the situation that we are trying to avoid, or trying to back away from, is that we want a harmonization of different regulations when this new act is operationalized based on...
Point well made and understood.
Okay.
Yes.
And the other point, Madam Chair, I believe it was already ventilated. Section 35 in respect of free of charge. Section 35(1), the operator of customs control area shall provide free of charge such facilities that customs control area be specified by the Commissioner. Notice in writing issued to the operator for officers to exercise their function under Part 13 in relation to goods and persons there. And our response was that this area requires a bit of explanation given the concession agreement, and of course it was also ventilated about the service level agreement, that the revision of the service level agreement negotiation would be facilitated in the context of this new regulation.
Really saying that government must remember that airports have been privatized, and it's not just in government control, because that is the subliminal message I'm hearing. And we take it in good stride in terms of understanding. But like I say, adjustments will come. And the approach is to enable, not disable.
Thank you, Madam Chair. And that's basically complete the submission of MBJ and the concerns that we had, particularly about our commercial and financial interests.
All right, thank you, Member Malahoo Fort. I believe the Airports Authority and are finished with your presentation. So we're going to invite, who is next? The Custom Brokers and Freight Forwarders Association. First of all, I want to thank you for taking the time to go through the bill, to prepare your submissions, and for making yourselves available today to take us through with your suggestions and concerns. Thank you very much on behalf of the committee. And I'd like to welcome now the Custom Brokers and Freight Forwarders Association. They're outside. If you could, someone could invite them in. Where am I?
It appears that the members of the team are uncertain as to whether they remain. If you choose to remain, through you, Chairman,
we want to
you
invite
can,
you to remain.
but we'll just ask you to shift seats with the other presenters. But you are at liberty to remain.
No, we're waiting on the custom brokers and freight forwarders. Can we have an update? Can we have an update? Oh, they're sanitizing. While we wait for just recommitting apologies for absence, we had received apologies from Senator Webby as well as from Senator Fraser Binns. I want that to just be acknowledged. So the sanitization is done now? No, inside, but no, not you, sorry. No, you're going to let them in now?
We have done 2 of the 4 so far with the MBJ.
Yes, and it would be good
Yes.
if we could get all of these done. I think we by 5 o'clock, hopefully.
Yes.
All right, good afternoon, and welcome to the Joint Select Committee that is reviewing the Act to replace the Customs Act. I want to thank you in advance for taking the time to prepare your comments and for sending those in. I'm just going to ask you to introduce yourself and then go straight into the comments that you have submitted.
Thank you, Chairman. Thank you. Thank you for having us. My name is Mitzi Gordon-Burke Green, immediate past president of the Custom Brokers Association.
And my name is Clive Cook. I'm the current president of Custom Brokers and Freight Forwarders Association. Thank you for having us, Minister.
Go right ahead, Mr. Cook.
Okay, great. Thank you. All right, first, let me say good afternoon to the chair, committee, Madam Commissioner, ladies and gentlemen. Let me just express gratitude on behalf of the over 200 custom brokers who are members of the Custom Brokers and Freight Forwarders Association, and we did have dialogue also with many other custom brokers who would not have been part of our association. And to just say we are grateful to be here, to be taking part in this submission and review, to further elaborate on our submission and this most consequential piece of legislation, the Custom Act 2020. Our association has been in existence for the past 55 years, over which time we have grown into the foremost professional body of licensed custom brokers, logisticians, and professionals engaged in custom clearance and third-party logistics processes in the trade of goods and services in and out of Jamaica. Mr. Chairman, we are hardworking, essential workers and professionals operating at all of Jamaica's port of entry and exit, and without us, the business of trade and commerce as we know it would not be the same. We consider ourselves that vital cog in the wheel of trade, commerce, and the retail business in Jamaica, and we are committed in our collaboration with our chief partner, the Jamaica Custom Agency, to ensure that the government of Jamaica derives the appropriate custom duties for the national treasury in support of the economy. In our submissions to you, Chair and Host, we trace the origin of the custom broker back to the Old English law, recognized and functional as an agent of Her Majesty's Customs. Over time, we have evolved to become disclosed agents representing the interests of our clientele of importers and exporters in the custom clearance process. We are therefore pleased that the Custom Act 2020 defines and recognizes the custom broker. This is of paramount importance to us as a professional body, given our stringent requirements for all custom brokers to be duly licensed and observant of all the regulations and operational requirements of the Jamaica Customs Agency. For us, standards and efficiency matters, and as such, we continue to invest significantly in training through international bodies, such as the International Federation of Custom Brokers Associations and the World Customs Organization, to ensure that we keep abreast of global best practices to be able to count it among the best in the world and in our service delivery. COVID-19 has been a big test for custom brokers in Jamaica, Chairman, and I dare say we have been acquitting ourselves well. In March and April 2020, at the height of the pandemic, the custom brokers of Jamaica rose to the moment of our times with resilience, bravery, and commitment. With the near shutdown of the economy, as custom brokers, we donned our N95 masks and worked tirelessly to clear vital imports of food and medicine in order to keep the nation's shops, supermarkets, and pharmacies stocked with supplies. So, Mr. Chairman, the bill recognized what many of our counterparts in the global community of shipping and logistics already know, that Jamaica licensed custom brokers already know about Jamaica's licensed custom brokers and logistics professionals. Just recently, we are happy to state that we were lauded by the International Federation of Custom Brokers Association for our tenacity and ongoing resilience in the face of the COVID pandemic. Mr. Chairman, the custom broker has two legal relations. one created by a contract of agency with the importer and the other created by the custom laws as defined by the bill and the regulations thereunder. The class of person defined as custom broker is recognized by the definition of custom broker in the bill. Therefore, by definition, the specific role, function, duties, and responsibilities of the custom broker are recognized. However, the definition of agent confuses and devalues, in our view, and appears to include a custom broker as an agent at common law. This, in our view, Chairman, defeats the intention of the bill, which is to create a separate class called custom broker, and a class of persons having professional duties and responsibilities and is statutorily liable under the customs law. To avoid this, Chair, we are recommending that the definition of agent be amended by adding the following words after 270, and not licensed under the Act as a custom broker or not being a custom broker. Also, Chair, under interpretation, Section 2, a declarant, it should be made clear that a declarant would not be a custom broker. We also have concerns with Section 11, which should state clearly that the responsibility for payment of duty would not apply to a custom broker. As mentioned earlier, we have grave issue with Section 270. 270.10 and 270.11, well, Section 210 correctly states, as recognized above, that a custom broker is not liable for the payment of duties. The exemptions created, however, seem to shift the burden of proof of a criminal act to the accused custom broker.
Sorry, is that 210?
Section 270.10.
270.10, is it? Okay.
Or 10 and 11. Right. In our view, Chair, these two sections are to be omitted because we, the Act, have already identified us as a custom broker. There's an entire section, Section 17 of the custom regulations, which already addresses how the customs may regulate, and all the rules are laid out as to how a custom broker functions. Under the regulations, you are liable to criminal prosecution if you step out of line in the fulfillment of your duties as a custom broker.
All right, so thank you for raising that. I mean, where the law is going, and it's consistent with other pieces of legislation and regulation, is that, you know, in an economy where persons are licensed to perform the kinds of functions, here, there's going to be a duty to ensure that you know your customer and that you take every step required of you to ensure that the customer does what is right. And what this says is if you do that, there's no liability. But if you don't, the law has to, we are addressing gaps that exist today. Where time and time again, we don't want to get too specific here, but you have aberrations at points of entry and you can't get to anyone. So let me just read what 10 says. 10 says, a person who conducts a transaction with the commissioner as a customs broker on behalf of another person is not liable for the payment of the duty and tax, fees and charges in respect of the goods concerned if A, the customs broker did not aid or abet the failure to pay, B, took all steps to prevent the failure to pay, and C, on becoming aware of the failure to pay, promptly notified the commissioner of the failure. Nothing in subsection 10 shall be construed as relieving a customs broker from liability in circumstances where A, the name and address of the person on whose behalf the customs broker purports to act is not disclosed on the goods declaration, and B, payment of duty and tax was deferred on the basis of a deferment granted to the customs broker. So the first section, if you do what you're supposed to do under the law and under the regulations, then there's no liability. And what the construct is that you are expected to do what you are called upon to do. But if you, for example, if a customs broker fails to include the name and address of the person, so there's no remedy for the state to pursue that person because the knowledge is not available, then the customs broker is liable. And that is the responsibility that you have under the license that you're carrying. And the state, the construct is to incentivize the kinds of activity that secures Jamaica's borders. And at a minimum, allows the state to have recourse whenever those rules are broken, and certainly to find individuals in instances when the rules are broken.
If you may permit me to ask a question, just to enable a better understanding of the concern raised. You're asking that the definition of agent excludes a custom broker, because you would like the custom broker to be considered as an independent professional.
Exactly.
But on whose behalf would the custom broker be transacting? In his own right or on behalf of someone else? Because the scheme, again, of the law enables persons who are transacting with the customs to appoint someone else, to appoint agents to deal with that person's business. And, I mean, if we take it outside of the law from operational standpoint, I'm importing goods, I'm not able to go, you're a custom broker, and I hire your services to transact and clear on my behalf. In that case, you would be my agent. I'm not kind of understanding.
All right, if I may address that, because what we have now is that the custom broker is not recognized in the statute. So we have our own responsibilities. I am acting on behalf of my disclosed principal, and that we really don't want to look at it as an agent because there are other complications as it relates to an agent in common law. But we want to be considered as an independent member of the law as a customs broker. In saying that, the responsibility of the agent, and I heard the chair, that we're seeking to tighten the borders, and so we need to hold somebody responsible. I like to use the example of we don't hold a lawyer responsible for the sins of their clients. And therefore, a customs broker, in the same light, should not be held responsible for what it is that the client does. If it is that I, in my capacity as a custom broker, would have committed or in breach of the law, then yes, hold me responsible. But it cannot be jointly with the importer, the exporter, or the declarant. There has to be a separation, and as I said, I like to use the example that the law now doesn't hold a lawyer responsible for the sins of their clients.
If I may, this is not a carte blanche holding responsible. It says, nothing in subsection 10 shall be construed as relieving a customs broker from liability in circumstances where A, the name and address of the person on whose behalf the customs broker purports to act is not disclosed. So the way to avoid liability is to make sure that when you act on behalf of an individual, you disclose their name and address. And this is covering a gap that exists that time and time again, infractions occur, and the state and the investigating bodies cannot find the individuals on whose behalf the broker is acting, right? So this is a very reasonable expectation of the Jamaican people that if you have a license to operate as a customs broker, that at a minimum, you include a name and address on a goods declaration. And if you fail to do so, and there's a problem, then you'll be held liable. You have a choice. So this is not carte blanche, wide open that you're liable. You're liable under these circumstances. And to avoid that liability, it only requires that you comply with what is being expected. I think that's a reasonable exchange or a reasonable expectation. You want to come in, member?
So what then would be the meaning of a disclosed agent?
All right. So if I may, we are not saying we are not a type of agent, but as presented under 270, we cannot be grouped with these agents. And there are serious issues with Section 270. If you look at 270.11b, payment of duty and tax was deferred on the basis of a deferment granted to the custom broker. That's impossible. Duty cannot be deferred and granted to a custom broker. The only way that happens
Mr. Edwards may
is
make an explanation in relation to that.
If the custom broker is acting as an importer, and this is totally outside of the scope now of custom brokerage.
But let me just a clarification. Do custom brokers import things for and by themselves, on behalf of themselves?
Yes, and in that case, they would not be acting as a custom broker. They would be acting as a importer.
Okay. So you still have not answered my question. The first question I asked. What then is the purpose of the designation of a disclosed agent?
No, I am agreeing with you. I'm agreeing with you that we are a type of agent. But having gone through this section with our attorneys, we hold the view that we should be identified as a custom broker, reason being that we already have an entire section in the regulation, Section 17, which lays out all the rules governing the business of custom brokerage. So in my view of the situation, if you look in the definition, you're defining a custom broker, and then you're defining an agent, and we're saying having us being defined under the law, we should be treated separately because we already. So we're not seeking to absolve ourselves of our responsibilities. We're simply saying we are already being regulated under Section 17 of the regulation. There's a whole section that speaks to the
but
custom
this is
broker.
a new law, you know. Yeah. So what it is that you believe, what responsibility has been slapped on a custom broker that you believe should not be a proper one in the context of the duties that you would be performing under this new law?
Well, first we have an issue with Section 10, because Section 10 seems to be shifting the burden of proof onto the custom broker. And we are saying, as a custom broker, we think this is infringing on our constitutional rights, because this is practically saying that we are to prove to the customs that we did not take part in these activities.
Sir, let me just say, I'm listening to you, and I'm asking myself the question: Isn't it that we've been operating under 1941 Act? You're 55 years old as a body, you said. Now, I am interested in having the customs respond to the particular concerns, because over that period of time, there would have been, and the minister alluded to it, the chairman alluded to it, and so I need clarity. Over that period of time, there's certain practices, there are certain activities, there are certain learnings that would have developed. We now putting in place, you say you support the repeal and replacement of the new act. Don't you think it reasonable that the new act would seek to address some of these learnings and these deficiencies that we've seen for the last 55 years? Are you expected to remain as is? And if you don't, then the question for me as a legislator is, what is the mischief that the act is trying to deal with? And has the act dealt with it reasonably and sufficiently? That's the question. So I'm just telling you, be careful that you come here and saying the act shouldn't do this and shouldn't do that. Be careful, because what the act is under New Customs Act, if you have practices and learnings and teachings, then I expect the New Customs Act to try to deal with it. So what I'm hearing from you, what I'd like to hear from you, is a reasonable basis for saying that this should not, that this penalizes you in ways that it ought not to. Now, when you raise this matter about constitutional right, let me caution you and say this. Be careful, because you first of all say that, unlike lawyers, you shouldn't be held responsible for your client's conduct. Let me tell you the difference here. You're acting within a framework that itself creates some opportunity for you. It's a framework of activities that have as its center the customs agency and the protection of borders and protection of revenues, as well as the facilitation of business, okay? So you're acting within a defined space and a defined framework. Within that defined framework, it is not unreasonable for the law to recognize specific sets of responsibilities and to assign penalties or regulate certain kinds of activities, so that it's not unknown for persons. Take the tax matters. The tax law shifts certain burdens because of the nature of the activities. So I'm just saying, the constitutional, I'm not impressed simply by the assertion that your constitutional right is affected. I want to hear more. How is that constitutional right? What is the basis for that constitutional right? How is it being affected? And if so, is it reasonably done to protect and advance the customs and the whole customs arrangement? That's what I'm interested in.
May I just add to Member Hilton's point for your consideration in clarifying your concern? Clause 270, subclause 7, indicates that when transacting business under this Act, an agent shall first disclose to the Commissioner the fact that he or she does so as an agent, and if required to do so by the Commissioner, shall produce to the Commissioner the form of appointment evidencing that person's appointment as an agent. And you indicated earlier that when you're transacting on behalf of someone, you're transacting in the capacity of the agent of this person. If you are in your own capacity, then you would be an importer. So within that context, further down the section, the other provisions are made. But I'm trying to understand the concern, because I really am trying to understand the concern, and I have not yet understood it.
All right, so as it relates to the concerns, and I'd want to take us back to a couple of the other clauses. If we look at section under section 108, it speaks to the declarant being responsible for duty, taxes, penalties. Based on our, it also speaks to their, on the section 2.1, it speaks to the exporter. The section 11, the bill is the cost.
118.
Sorry,
Under
118.
118.
108. Sorry,
108.
Sorry about that. It speaks to the declarant. In looking at the act, and while we will agree that in areas of under 270, it gave some consideration, exception for the customs broker. Throughout the rest of the act, as it relates to the declarant, the importer, the exporter, there's no exception for the customs broker. The customs broker is lumped with the importer, the exporter. Now, in our capacity, what we do...
So clause 108 falls under the subpart dealing with government warehouses.
And it speaks to goods being deposited in those warehouses, and when the goods need to be deposited, now the cost becomes that of the declarant and the importer. And in looking at the act itself, our understanding and what we got from it is that we are being held in the same way as the importer and the importer, declarant, and the exporter. Yes, there are some exceptions for us in 270.
Please just point me to that clause in that section, that part of the provision in clause 108, which conveys that to you.
No, well, it speaks to no if the expense of the declarant, or if no declarant, the importer.
Right. So let's understand. First of all, a place that is designated under the relevant section to be a government warehouse shall be operated by the commissioner or by another person with the written approval of the commissioner. So this is a specified space that is reserved unto the government with operations under the authority of the commissioner and subject to the terms and conditions in accordance with the rules specified in the approval. So the entire operations of it are subject to the directions given by the commissioner and in accordance with the specified rules. 108.1 speaks to that clause is dealing with removal of goods. So the commissioner may deposit goods or cause goods to be deposited in a government warehouse at the expense of the declarant, or if there is no declarant, the importer or exporter, as the case may be.
Right.
If the goods are imported goods required to be cleared in accordance with this act, and the goods have not been cleared within the specified time under the act, if the goods are required under any customs law to be exported and the goods have not been exported within the time specified in the applicable law, or if the goods are subject to a lien under the act, are detained, seized, or confiscated by the commissioner under the act or any other law, or for any other reason are required to be secured by the commissioner pursuant to this act or in any law. So the commissioner may, for the purposes of the subsection, determine the government warehouse to which the goods shall be deposited. What is the concern of the operation of the government warehouse where certain goods would be put for specified reasons in relation to duties of a custom broker?
The concern is not the operation, but if a fee should be incurred, then it would be for the account of the declarant and or the...
So tell me where in the law that's provided for. Which section?
No, it says here at 108, the commissioner may deposit goods or cause goods to be deposited in a government warehouse at the expense of the declarant, or if there's no declarant, the importer or exporter, as the case may be.
Right, but that's conditional on the goods not being cleared in accordance with the act, or the goods have not been cleared within the time specified, because goods that are imported have to be cleared.
Right.
So it is or if the goods are to be exported, they are not exported in time. So the incursion of fees relate to something not being done in accordance with the law.
Understand?
Right.
The fee that is incurred, however...
So who should be liable for the payment of those fees if goods are not cleared in accordance with the Act, or if the goods have not been cleared within the time that is specified? Who should be liable?
The person that should be liable will be the owner of the goods.
So in that case, so the importer or exporter, as the case may be.
Right, and the declared principle. Now, the reason why it is of concern for us is
don't let's rush over that, because we need to understand the point you're making. So here, the responsibility rests on the declarant or on the importer or exporter if there is no declarant.
That's correct.
Because you know that someone imports, there's a whole string of paperwork that is involved in the importation and exportation of goods.
Right.
And the importer may not be one and same as the declarant in the clearing process.
And that is the concern,
but
Madam
from practical purpose, but that's what operates in the industry.
Right, and that is the concern, because with that, the customs broker, based on this and there are other areas that we would have made in our submission which would have been presented, there's no clear indication that the customs broker is exempt from these responsibilities.
So let me tell you why you have already answered your own concern. You've indicated that as custom broker, if you're importing or exporting in your own cause, you're the importer or exporter.
Right, so that's
and the liability would be placed on you in that, sir. And if you're operating on behalf of someone, you may be the declarant or the agent, right?
No.
If you, a custom broker, when is a custom broker the declarant for the importer or exporter?
Based on the definition for declarant, it says it means a person who makes a goods declaration to the commissioner or in whose name a goods declaration is made to the commissioner.
Right. So when the custom broker is clearing goods on behalf of someone, whose name go on the paper?
All right, so on the documentation, what we have now is that the importer would be declared, the declarant, but in discussion...
Who would be the declarant?
The declarant on the current system is the customs broker.
There you go. There you go.
And that is the problem, Madam AG, because where the declarant is held in the main of the act for certain indiscretions, then it would mean it is the customs broker. So, and I'll give you an example. If the customer imports a shipment and he has presented to us their invoices, however, we would not have known that these invoices are not genuine. But in doing their investigation, customs recognizes and a breach is to be put in place. That breach should be to the owner of the goods, not to the customs broker. And what we have now with the declarant being the customs broker with this definition, it puts us in that responsibility. And a lot of times we will not know that there's an error. I'll give you another example. A few years ago, we were being held in the same regard as an importer. And what happened, an importer brought something in, wasn't able to fulfill their requirements. The customs broker's license was not renewed. The sin, and I call it that, was on the importer, but it's the custom broker's license who wasn't renewed, and the customer was able to continue operating as an AEO. So what we're doing is shifting the responsibility to the small man, the MSME, and then the customer is still allowed to go. Another customs broker lost his license.
You though, but just in accordance with your narrative, do you see that the law has taken care to specify that no liability would be incurred if there is no aiding and abetting in the failure to pay? In other words, if you have not been part of the reason why there is a failure to pay, then you have no responsibility.
The only thing, Madam AG,
and if you have taken all steps that are required to be taken by you to prevent the failure to pay, given the duties that you are performing, then you don't have liability.
The only thing is that from our understanding, it does not cover us for the entire act based on the other definition, to include the one I just read for the declarant, because clearly how we interpret it now, we are the declarant. But that 270 section that gives us some exemption, it is not understood that it gives us that exemption throughout the act. So that is what we would want to be considered.
But under all circumstances where you're conducting business on behalf of another person, let's look on the particular language that is used. A person who conducts a transaction with the commissioner as a custom broker on behalf of another person is not liable for the payment of the duty and tax, fees and charges in respect of the goods connected. So where in those opening words you would see any limitation in terms of your transacting right across with the commissioner?
Well,
yeah.
Yeah.
Yes.
All right, yeah. All right, let me have
Clause 270.
I heal.
Really trying to see if the point is, but Hazel, you can.
I think some of the difficulty that we're having is the fact that we have a current practice, and then we have this new law that is suggesting a new way of going forward. And I think sometimes we're not able to properly appreciate what the distinctions between what we intend to do going forward versus what we are doing now. So the proposal in this new legislation is that once a customs broker is acting on behalf of another client, of his client, you will have a choice. You could opt not to disclose your principal. So the customs broker can make a choice, depending on the contractual arrangements that exist with his client, that he will come forward as the declarant in relation to those goods. However, if the customs broker fails to disclose his principal, he will be assuming responsibility for that transaction.
And that's fundamental. I mean, that's absolutely fundamental. That's not something that we can ever compromise on.
May I just add again, in respect of the concern raised about the protection, as they're saying, not carried through. The part of the law that this section falls in, that the clause falls in, is part 15, which are general provisions. So if you look at page 169, well, you may have another version, but these are general provisions that apply across the board. So if I can allay your fear that once you are conducting business as a custom broker on behalf of another, you are not liable because liability kicks in where there is failure. There is some failure, because we all know that in the importation and exportation of goods, there are fees that are incurred. So a liability would only be, you're not liable if you did not aid and abet the failure to pay. There are no limiting words in the provision. So I don't know if. So just take a look at it.
And if I may just relate it to other schemes that are, the whole pushing our money laundering legislation, and under the, Jamaica to come out of the designation that we have now, in certain segments, whether it be the gaming segment or it being real estate or accountants, etc., there are requirements that professionals have to adhere by in order to protect the system. And if they don't adhere by those requirements, then there's a possibility that they face liability. I mean, there's a small state like Jamaica that has over 90 points of entry, in addition by sea, in addition to several by air, and where trade is 80% of GDP, and where we have, we have been infested with crime, right, that uses the same borders that legitimate businesses use, we can't be wishy-washy about this issue. If you are not going to disclose your principal, then if something goes, under the conditions that are specified here, then you step into the principal's shoe and you become liable, but only in those conditions.
Understanding, Mr. Chair, and I think we need to just restate that we consider ourselves professionals. Yes, you do have things that happen in the industry, but when we speak, we do understand that if we have not disclosed our customer, then on the documentation would be more than likely our name. And there's a separation. In that case, we are an importer. And so we are not speaking to those instances. We are speaking to the instances where we are acting as a customs broker. Madam AG, you mentioned that the general section as it relates to 270 that gives us the exception will do so for the entire act. But we had the concerns because when we looked at the definition for exporter, we looked at the definition for declarant and importer, we did not see that separation, and we did not, in all our deliberations, did not see that that section in 270 would give us the overall exemption. They also, as in practice now,
clear. It's not really an exemption. It's speaking to what you would or would not be responsible for when you're acting on behalf of another person,
right,
in respect of the payment of the duty and taxes, fees and charges for the goods concerned.
That's correct.
In the transaction.
Can I ask you to just look for us at the definition for declarant? On the documentation, on the custom system that we use now, ASICUDA, we are entered as the declarant. That's the only section for us. And if we look at the definition for declarant, considering what was just said, how is that viewed in relation to the customs broker?
Mr. Lowe, speak to that for me, please.
Chairman AG, we can admit that there's a labeling issue, so it's less of a legal issue. There's a labeling issue on the form, and that we can look at and try to correct that.
The custom brokers don't want to feel marginalized, minimalized, because they are saying that they are recognized players in the industry. So if that adjustment would address the concern, we'd be happy to make it.
Yeah.
All right?
Yeah.
Good. Yes.
No, I agree with an adjustment might be necessary on that point. But just to understand that, the good thing about the direction of this, as I understand it, is that we're making distinctions based on an activity, right? On the verb, not on the noun, who the person is. Because who the person is, the customs broker can be, as you have in your, can be an importer, can be the importer, can be the declarant, can be the agent. Okay? So if you wanted to use the word custom broker, then we would have to limit what a custom broker does. But the way to retain the flexibility is to have the provisions be attached to the activity. If somebody is the importer, somebody is the declarant, somebody is the agent. Okay, it doesn't mean that we can't accommodate what you're saying. So let me start by saying I accept the very last clarification that you made with the definition of declarant. I accept that. I'm just going back just on a principle basis, a higher level principle basis. I'm not attaching it to any particular provision. The higher level principle basis is that we achieve much greater flexibility by attaching the clauses to the action being taken. Right? Whether somebody is declaring, whether somebody is importing, whether somebody is being the agent, and that allows the customs broker with the license the freedom and the flexibility to, for some clients, you might be the importer, right? For some, you might be doing the declarations, and for others, you might just be, the agent as we understand it. And that flexibility, I think, is consistent with what we want for you to just to do business and take business on, etc., etc. But it does not obviate the need for us to attach certain responsibilities with certain actions. So the responsibilities are tied with the action, not with the definition of who somebody is. Yeah? But we will take on board your suggestion with that very last point and move on. Senator Hill?
Chairman, thank you. Is there ever an instance when a custom broker would have clearly defined the importer who is their client as the declarant, and then a problem occurs, as you're trying to avoid here?
I'd say 95% of what we do, the importer is declared. It is a declared principle. There are situations where we do provide...
No, that's not my question. That's
Sorry?
not my question. Now, my question is not if there's 95 or 99 or 88. My question is there a time when you would have declared your client who's the importer as the declarant, and then the custom broker would have been caused a problem subsequently?
Yes, we have had those instances, and I'd alluded to one earlier. There are others where the customer did not provide the information that needed to be provided, the process could not be completed, and the customs broker is held liable. There are examples. The last one that we dealt with is that the broker lost his license for 4 years because the shipment was cleared on a letter. Then the customer could not provide their tax compliance certificate. Now, that is something that a customs broker cannot fix.
Just a minute. So then the custom broker did not have the correct declarant on the form?
No, but yes, the importer would have been declared correctly.
The importer was declared properly as the declarant?
Yes.
And you still had a problem?
Yes, sir.
So under the scheme...
Then you have to find a solution.
No, but under the scheme, if something like that were to recur, once there is a failure to pay and you become aware of a problem, and you have a duty to promptly notify the commissioner of the failure.
But even
and also, in respect of the definition of declarant, qua custom broker, you may or may not be the declarant, because it is defined here to mean the person who makes a goods declaration to the commissioner, or in whose name a goods declaration is made to the commissioner. So if
that's your choice.
Through you, Chairman, yes.
Member Dunn?
I think I understand what Ms. Sims is saying, because in this case, in this particular clause, then the burden of proof is shifted to the custom broker for them to prove that they were not part of that illicit scheme to defraud the government.
Someone is liable for the payment of the duty and taxes, the fees and the charges. Someone is liable. All right? If the custom broker is transacting on behalf of that person, the custom broker would, I suspect, in the normal course of things, if it's not coming out of your pocket, you would ensure that the person is providing you with the relevant fees and charges to be paid over. Isn't that how it is done? I'm not understanding.
That is how it is done, but in the instances where the customer is delinquent, then we want to make sure that it is not the customs broker that is being held for that payment of duties,
right,
etc.
So you're still not convinced that the clause...
No, it was a question that came up, but it's just that obviously Mr. Lowe spoke to the relabeling.
Right.
You have indicated that the general clause in 270, from we are acting within our correct capacity, then that would cover us throughout the law.
You don't have to take my word for it, you can read it for yourself.
I'm going to ask, just in the interest of time, I know you have other points to raise, I believe.
Yes, we do.
So can we move on to those points?
All right, thank you, Chairman. All right, the section which we took issue with, Chairman, is section 115F. All right, and this again refers to when there's a
115, is that 2F?
Section 1, yes.
Subsection 2F.
Subsection 2F,
okay.
Right. We're saying here again that these are when goods are being disposed of at an auction, right? And the customer will have an obligation to make public the owners of the goods and the type of goods and so on. We're saying we don't see any legal basis to attach the name of the custom broker.
You know, we agree with you on that. I agree with you on that. That we can definitely remove that if the committee so agrees when we go through the clause by clause.
Thank you, Chairman. We also seek clarification, Chair, on section 33(1). In that the section, as custom broker, you really want to know you want to have a clear indication at what stage of the process what is the beginning then of your duties as a custom broker and where does it end, right? So for section 33, we need some clarification because it states that imported goods come under custom control from the moment the goods are imported until the goods are cleared for free circulation, right? The issue we're having is that there's no definition of cleared in the act, right? There's a definition for release. So as brokers, we normally refer to the release of the goods. But we are seeing this term cleared for free circulation.
Clearance is defined, eh? Clearance is defined. And clearance in relation to goods means the accomplishment of the requirements necessary under the custom laws to allow the goods to be placed under a customs procedure. So clear is construed in accordance with clearance.
It wouldn't, as it relates to what we're seeking to achieve here, the definition of clearance would not address that, because based on the definition of clearance, it is putting the goods under a customs procedure. So that means it is not prepared for free circulation.
Let me ask the customs to explain it, please. Through you, Chairman.
So free circulation means that the goods are no longer subject to a customs restriction.
Right.
Now, obviously, once the importer has executed, or the declarant, let me say the declarant, because the liability really is the declarant's liability, has done everything that is required in order to either put the goods under a particular customs procedure or cause the goods to be no longer under any type of restriction, right? Then that declarant would have accomplished all of then we can say that that person has cleared the goods. It must be recognized that you can have an instance where a person, or where the customs initially formed the view that the goods had been cleared and therefore we issued a release, but then subsequently it is discovered that the person had not in fact done everything that is required in order to comply with the customs laws. But in relation to the customs broker's responsibility is to do whatever it is that his principal has charged him to do in terms of in terms of the activity that the customs broker is hired to do. And of course, to perform that activity in accordance with the professional obligations that are imposed under the customs laws.
When you're looking at the definition of clearance, which ends in allows the goods to be placed under a customs procedure. Now, there are several customs procedures. I have to agree that I hear the comments you make, but I think it does keep it a bit murky, because in the other definition, on the particular provision that the member spoke to, it spoke to free circulation. Now, at what stage that you're saying, and your response suggests that previously under the old procedure, there was a release, but then you would find subsequently that not all the steps were concluded. And you're not holding yourself as custom responsible. You're shifting it to the broker and saying, well, you're the professional. You should have ensured that all the steps were concluded. Because it remains for me a bit murky if you're saying once a custom procedure, that it invokes a customs procedure. It leaves a lot. Which procedure? Because there's several stages. And the clearance, I would agree. I have to agree with the custom brokers. You really need, if you're going to attach liability, you need clarity. And we need to have it at a stage. Huh?
But in this clause?
Yeah, no, I'm saying you cited in response to the custom broker, Mr. Cope.
The clearance definition.
Yes, you cited the clearance definition. That doesn't produce the clarity that I think is necessary if you're trying to pin the liability, because then the question remains, which of the procedures that allow for free circulation? That's the question in my mind.
Well, I think it's important to recognize that the provision at section 33(1) is dealing with customs control, which is a broader concept. All right. Is it any better? I think it's important to recognize that 33(1) is dealing with a broad concept of customs control. And it's a general principle that until goods are no longer subject to a customs restriction, they continue to be under customs control. Pardon me? Yes. Perhaps on review, the use of the word are cleared for free circulation has caused a difficulty, and so perhaps we could, in consultation with CPC, see how to adjust it to say until the goods enter free circulation, or well, we'll find an appropriate language, essentially until they enter a certain state where they are no longer subject to customs control.
Yeah.
Right, but the definition of clearance is accurate because it refers to the fact that the goods must enter, or the goods must be brought under a customs procedure. And even home use, which is when we have use goods domestically, that is identified as a customs procedure. All the various activities, all the various ways in which goods can be treated have been classified under a particular customs procedure. So I think perhaps the difficulty that we have here is because we have used the word cleared, and I think if we adjust that, we will not have any difficulties. And the provision is not dealing with liability. The responsibility of clearing goods will rest with the declarant. The responsibility of the broker is to act as agent in accordance with the professional responsibilities. But unless he's aiding and abetting on the other issues that we mentioned, the responsibility is not the broker's. It's his principal's responsibility to ensure that the law.
But the broker.
Senator Johnson Smith wanted to come in.
Just a quick comment.
Just to clarify, on your same point, you know.
Yeah, okay.
Just to seek some clarity, thank you very much, Chairman. The definition of release specifically speaks to the process to place the goods at the disposal of the declarant, which sounds to my lay ear very similar to being cleared for free circulation, conceptually. You have just said that you do think that there needs to be some greater clarity and that perhaps the issue is the use of the word clearance. And I'm just wondering what the difference is. And not to revisit the point about discovering an error and there still being a requirement for process, because the issue is not whether something incorrect has been done or not. The issue is whether the goods are now ready for free circulation or not, and that's slightly different. So I'm just trying to understand why you wouldn't use release, or whether in fact that does solve the issue, given the definition that's provided for in the Act. If there's a distinction, it might help us later down the line to understand what that distinction is.
We would not use the word release here, because release, in terms of Act Section 33(1), release is the activity that customs performs based on, if I should use the word, the application, which is essentially the goods declaration. So the declarant has certain goods, and the declarant says to customs, I would like these goods to be treated in a particular way. I would like to put these goods in a warehouse, which is a warehousing procedure. I would like to use these goods in a special economic zone. I would like to use these goods for home use. Having received that request, which is based in the goods declaration, customs will then release it, which is essentially say to the declarant, you may now do what you have said you wish to do with the goods. But if we were to utilize the term release in a provision in Section 33, we would create a difficulty, because, again, the provision is dealing with customs control. And the grounding of responsibility in the customs laws is the goods declaration. The fact that the declarant has said certain things to customs, and on the basis of that, customs has taken a decision. So you may have a scenario where customs has released the goods, but if it is that we acted on the basis of inaccurate information, in other words, we released it, but then we no longer have control of the goods, it prevents us from them coming back to the declarant to say, well, we now know that you provided us with inaccurate information. We gave you a release, but guess what? That release is not valid. And these goods continue to be under our control in terms of reassessing for duties and taxes that were not paid, or perhaps taking possession of the goods in circumstances where the goods were handed over to the declarant for a particular purpose or so. So we could not utilize the word release. We could not say release for free circulation in a provision that is treating with the scope of customs control. The idea is that customs control begins when the goods are imported and ends when you have complied with the law, even if we had issued a release. The crux of ending customs control is compliance.
Chairman, in the interest of time, we will note the concern and we will note the clause for further consideration. All right? Yes.
So thank you. You want to go on? Continue? Any other points?
Yes, yes, I'm looking to wrap up, Chair. All right, so Chair, we are also proposing because we know the regulations are on the horizon to be looked at. As custom brokers, we are seeking to have a standard form contract as maybe an addendum to the regulations, which will clearly state so the terms of contract with the with the importer, right? And with the importer and...
Mr. Coke, you really want the government to interfere with your freedom to contract? Take care with what you ask for. You know, on the one hand, you're telling us about recognizing custom brokers and not diminish your stature in the whole procedure. And on the other hand, you're telling us now that we must prescribe how you contract with your principal.
Yes, because the truth is...
we're not here to micromanage your business, you know.
That your customers won't want to comply with the contract. Is that the concern?
I think we're looking at, because currently we do a C-73, which is an authorization to act on behalf of an importer and exporter. Now, what we're suggesting is to expand on that. So we have a standard form. It would not include our commercial business, so our rates, etc., would not be in that document. It would simply be a document which the broker needs to adhere to, the importer needs to adhere to, and it would also help the declared principal position.
Remind me of your name, please.
Mitzi.
Surname?
Gordon Burt Green.
All right, Ms. Gordon, for short. So what we're seeking to do is to delineate the responsibilities in terms of activities and roles. And then you be guided in terms of what the law requires of you, what the law requires of your principal. But I beg you, please, don't ask us to interfere with your freedom to contract in the broad sense. That's free advice to you.
I think they're acting on some legal advice. But no, I would agree with the AG that I don't think we want to enter into that space between the client and the broker. You're the professionals.
Setting the parameters for operation. And we're trying to do so in an unprecedentedly clear way. But remember, we're moving forward. We're not standing still. And be assured that we would take no step to diminish your very important role.
Thank you. All right, in continuing to wrapping up, Minister, an area of concern also is that the efficiency which we are seeking with this bill, being practitioners, remember now in terms of the clearance of the goods, it is not just the Custom Act that we have to interface with. There's also the WAF, and part of our thinking as a group is that we may have to look on the Wharfage Act and maybe by extension the Port Authority Act. And certainly in our discussion, one of the things which I think we can benefit from is to having the WAF operating, of course subjected to discussions on a 24-hour basis. In that way we can see our lorries leaving the port at night. I know it is something with the truckers have asked for to be able to return containers on the weekend and to work to late hours in the night. I know part of the concern would have been overtime to pay to various agencies, but our thinking is that we can look on a shift system. As it is right now, the port has certain activities which they do carry out 24 hours, and also the customs have activities. So I think it would really benefit our sector by having all the stakeholders looking at how we can operate along these lines. But of course, we'd have to look on the Wharfage Act. We haven't looked on it in details, but just in reviewing the Custom Act, we look onto aspects of that. And finally, Minister, the last thing which I will bring is another thing which I think will help us is the categorization of certain items which comes from from the ministry in terms of how they are dealt with for classification for us at customs. An example which came up in our deliberations is, for example, a solar system. So you may be importing one system, and if you import it together, you're fine. You know how it is treated. But when it is broken down in parts, and it happens sometimes, you may get different components. You may not be able to get everything from one supplier. So we are saying this act, I have publicly commented on it that that's a good act. We are heading in the right direction. But we are saying we can, in terms of the categorization, we can put a simpler system or look at putting a simpler system in place to achieve the overall effectiveness which we all seek. I thank you, Chairman, and I thank you for affording us this opportunity.
I just want to thank you, Mr. Koch, and Miss Mitzi Gordonberg.
Thank you for having us.
For representing the custom brokers of Jamaica, over 200 of them, and by reviewing the bill, reading it very closely, and making your presentations here today. We appreciate it very much. And we'll have a better bill because of your contribution. So thank you.
Thank you, Minister.
Thank you too, Minister. Thank you.
All right, it's now 4:43, but we had invited the Shipping Association of Jamaica. They've been waiting patiently outside. I think we need to bring them in, even if it means that we don't finish with them today. Yeah? And would I have members, I know we have curfew and so on, but if we went up to 5, what would be reasonable, 5:30? Would that be reasonable? Okay. All right, may we invite them in? We may lose a few minutes as we did last time with the sanitizing and so forth, so just bear with us under the protocols. Yeah.
So, Minister, they're already inside, so they will just...
I don't recognize you with the mask on. Is that Cora Ann? Well, good to see you. So we're going to ask you to move here where you can speak, but they're going to sanitize. But maybe we can begin, just for the interest of time, let's begin where you are. And once the sanitization is finished, we're going to ask you to move up, move here.
Good afternoon, Chair and members of the Joint Select Committee.
I'd just like you to introduce yourself so we know where.
So I'm Anna Hamilton, representing the Shipping Association of Jamaica.
I didn't get the name. Say the name again.
Anna Hamilton.
Okay.
I'm representing the Shipping Association of Jamaica. I'm also the CEO of Jamaica Freight and Shipping Company Limited. And I'm accompanied today by my colleagues Cora Ann Robertson Sylvester, Vice President of the Shipping Association of Jamaica and CEO of Seaboard Freight and Shipping Jamaica Limited, Corinne Williams, Director of Sales and Marketing with Seaboard Freight and Shipping Jamaica Limited, and Dion Mason Gordon, Operations Manager for Member Services for the Shipping Association of Jamaica. The Shipping Association of Jamaica welcomes the process to repeal and replace the Customs Act of 1941, and thanks you for giving us the opportunity to speak to this Joint Select Committee of Parliament on same. The Jamaica Customs Agency plays a critical role in the movement of cargo in and out of and within our borders. It is therefore vital that this legislative framework focuses on those areas of regulation that are necessary for the agency to carry out its functions, including trade facilitation. The Shipping Association has already provided the committee with our written submission, and we take this opportunity to emphasize particular concerns that are included in our submission, namely the role of the shipping agent and the liabilities that the Act seeks to impose, registration of shipping agents, logistic services, sufferance wharves, and the level of uncertainty embedded in the legislation, because many of the provisions are to be further detailed in regulations which we've not had sight of. You will also note that throughout our comments, we have emphasized the importance for focus to be placed on the ease of doing business and the need for consistency and predictability in customs administration. Section 2 of the Act defines agent as a person appointed under Section 270. However, while Section 270 does not set out a clear definition of agent, one can glean from paragraph 9 of Section 270 that an agent could be any person acting on behalf of another. We consider that to be too wide-ranging a definition for such a key role in the industry, and we believe that it would be useful to include a definition of shipping agent to include non-vessel operating common carriers. We are of the opinion that the Federation of National Association of Shipbrokers and Agents, FONSABA, best describes the role of a ship's agent, which we have included in page 4 of our comments to assist the drafters in setting out a definition for shipping agent. There are several provisions in the bill that seek to hold the shipping agent liable for acts of their principal, that is, the carrier or shipper. We contend that a shipping agent should not be held liable for the actions of his or her principal when an agency relationship has been disclosed. In instances that said agency relationship has been disclosed, the shipping agent should be exempt from liability, much like the customs broker is exempted in similar instances. We understand the government's need to secure its revenue and believe that this can be done by a vessel clearance or international carrier bond that would be crafted to address local laws and financial responsibility for penalties. We understand that this is not a new concept for the Jamaica Customs Agency, and in fact, similar arrangements already exist for the custom brokers associations.
So, Anna Hammond, I'm going to ask you to, if you could just break and relocate here. When we can see you, it performs better, but we're happy that you started and we got the first segment.
Okay. I'm coming now.
Thank you.
Maybe they didn't realize that there are seats here.
Okay, so I'll continue. Okay, so it appears that Section 270, read in conjunction with Section 181, requires shipping agents to register or be appointed in accordance with rules to be prescribed by the Commissioner. Whilst we do not object to the process of agents registering for use of the automated system for customs data, ASICUDA, or any future customs management system, we do contend that regulatory registration of shipping agents by Jamaica Customs is an unnecessary imposition. We have found no precedent for such customs appointment of shipping agents in any country with a highly developed logistics profile. We are therefore of the opinion that paragraphs 3 and 6 of Section 270 should be deleted and the remaining paragraphs redrafted to omit reference to the rules. The provision should provide for the agent to be appointed by the carrier and that such appointment should be in writing. Nonetheless, we do believe there is value in the registration of participants in this market and propose an industry regulation model which could be enshrined in legislation. Jamaica has been promoting herself as a logistic hub of choice in the Americas. While we recognize the need for regulation and for revenue such should not be at the expense of facilitating business. The Customs Act 2020 creates what appears to be artificial distinctions between transit, transit to export, transshipment, and coasting trade to differentiate movement of goods between local ports and between local and international ports. As noted on page 7 of our written comments, the effects of the Act as drafted would include a vessel only being allowed to move cargo from one port in Jamaica to another port in Jamaica by sea if it has been specifically designated a coasting vessel, and transshipment being limited by definition to movement of cargo from one vessel to another at the same port. The Shipping Association of Jamaica urges a joint select committee to consider these provisions further. A successful regime must provide a single process to facilitate transshipment from any port other than the entry port, and the streamlining of the relevant documentary procedures to allow for the importation of goods via any port and exportation of those goods via the same or any other port, the storage of imported containers and transshipment containers in the same place without adversely affecting the definitions of the transshipment area and the customs territory, and for the movement of goods via road without the requirement for special customs escort to be obtained. These requirements are counterproductive and increase the cost of doing business in Jamaica. It is important to also note at this juncture the concerns we set out on page 11 of our comments with respect to coasting trade. Again, we emphasize the ease of doing business and the need to ensure that the legislative framework is practical. The current situation is that all of the vessels which engage in any form of coasting trade originate from outside of Jamaica, and all of the cargo also originates from outside of Jamaica. The provision does not appear to embrace this reality. We reiterate that the legislative framework must reduce the cost burden and the level of bureaucracy associated with logistics and transshipment trade and take into account shipping realities. The fee structure must be uniform, practical, and consistent. We also want to draw your attention to our comments on pages 8 and 9 of our submission, where we indicate our concerns regarding the definition of sufferance wharves in the Customs Act 2020. It appears that the Customs Act 2020 is attempting to widen the definition of sufferance wharves set out in Section 4 of the Wharfage Act. The definition in the Customs Act appears to focus only on the nature of the cargo and does not import the traditional restriction regarding the ownership.
If I may, just in the interest of time, since this section is a long section, your sufferance wharf point is, we accept that.
Is noted.
That was a slip. I don't know how that got through. We accept that.
Thank you.
So let's move on to the next one.
Okay. In our review, we note further that many of the matters on which we were previously consulted by the Jamaica Customs Agency have been removed from the draft Customs Act and are to be addressed in the regulations. This, we believe, creates a level of uncertainty as the stakeholders, we, have sought to comment on a framework of changes on new positions without having the possibility of knowing how they will be implemented. Of particular concern to us is, one, the timeline for the submission of advanced arrival and departure information. Current legislation requires submission of a ship's manifest 24 hours in advance of intended vessel arrival. However, this new act will require the submission of additional information, such as what is called for in Section 50D, the submission of a list of the cargo on board the vessel or aircraft that is not intended for discharge in Jamaica. 2, how this advanced arrival and departure information will be treated for short transit routes. And 3, the introduction of no loading notice as per Section 52 and how same will be treated. What seems to be a heavy reliance on regulations is of concern to the Shipping Association of Jamaica, in particular, again, because of the absence of said regulations. It does not appear as if Parliament will have oversight of the enactment of some of these regulations, but that rather some will be enacted by the Commissioner or the Minister without same coming to Parliament. We are unclear which, if any, of the regulations will come for debate in Parliament, and we're therefore concerned that the Shipping Association of Jamaica, as key players, will not be afforded the opportunity to have sufficient time for review and consultation. We also do not find the method of notifying the public of the bringing into operation of any of the regulations or rules under this Act by publishing them on the Jamaica Customs website adequate, and would propose strongly that other forms of public notice also be mandated, such as publication in the newspaper. We note further that the Act allows for regulations to come into force after 21 days, and again, we do not believe this to be adequate time for proper review and consultation. Finally, but certainly not least of our concerns, is what we consider to be some level of inconsistency and unpredictability, which we have found to be the case with many aspects of our interactions with the Jamaica Customs Agency. We believe that the drafting of this new Act is an opportune time for these factors to be addressed. An area of concern over many years is customs overtime charges. We recommend that this Customs Act should include an amendment to the working hours for customs officers to 24 hours flexi-time rather than the current 8 to 4 or 8 to 3. If Parliament determines that the working hours should not be changed, we recommend a clear process that will allow shipping agents and their principals to accurately forecast their costs. Another area of concern is customs auctions. Currently, there is no provision made for the outcome of customs auctions to be reported to the interested parties. We believe that the application of the proceeds of sale should be known to parties that have an interest, even if said parties are identified by category only and not named. In conclusion, we again want to thank you for affording us this opportunity. We would encourage the committee to ensure that the Customs Act 2020 is drafted in simple, plain language so that the users of the system can understand. We do want to applaud the Jamaica Customs Agency for their effort to repeal and replace the Customs Act of 1941 and look forward to the committee's serious consideration of all the points raised in our written submission, which we believe will assist greatly in this effort. A modern Customs Act must embrace the tenets of consistency and predictability, which can only result in increased competitiveness and growth of the Jamaican economy. Thank you.
Thank you very much for your comments to the bill and for taking the time to take us through. We won't be able to sort of exhaust all of them in this part of the process. How it works is that we hear submissions, we have them written, so they're with us. We hear them, we discuss the major aspects, and then when we have heard all submissions, we go into a clause-by-clause review of the bill, which is more detailed. And we're not going to do clause by clause today. We want to just use the opportunity to discuss the main comments that you have made. Right? So I'm just going to open it up. Member Hilton had indicated first, ask him, and then Member Mallohu for.
Thank you, Chairman. Thank you very much, Ms. Hamilton, is it? Yeah. Firstly, I think there is much in the presentation that commends itself to this process and to the improvement of the process. The issues of predictability and consistency must be a principle enshrined and implemented. But my particular area of first of all, I think the shipping agent argument is to be looked at very seriously, particularly when you look at the disparity between. We just had the freight forwarders and custom brokers before us, and a good part of the discussion was about the disclosed agent principle. which avoids certain liability. I imagine that part of the issue for the differentiated treatment had to do with your principle and where they are and how to find them. But I think the bond issue responds adequately to it. And therefore, I would want to commend to this committee that we look at the scheme and address the issue, because there is some unfairness about it, to impose those liabilities on shipping agents in circumstances that they clearly have nothing to do with the instructions given or the decisions made. So I think a scheme that seeks to, I haven't looked at the particular definition that you propose, but I would imagine that if it is utilized elsewhere to solve this similar problem, that it would commend itself. But that, in addition to the bond, I think could secure the government's practical interest in being paid, and at the same time being fair to the agent. So I'm inclined to it, and I'm going to come back to that to see how that is addressed. My other area of concern is the logistics. Yeah? I agree. Madam, we have to find a way to look at, and I'm not sure, and it has to be explained to me, these definitions. And the one I find I have some sympathy for is the coasting. I think we need to look at that and to see whether the definitions are practical definitions, one, but more importantly, do they assist a process? Now, the reason I'm concerned, the government has announced as part of its initiative home porting. Now, to my mind, home porting involves the importation of not only people but goods and other services. If I recall the logistics, much of I can imagine people coming in at both airports and having to find their way to the ship somewhere, and goods coming in and having to find their way to the ships. We can't encumber that process in a way that adds cost to it, or else we won't be recognized as no home port. People will simply ignore us. So we need to look very carefully at that process. And also, more generally, I'd like to see, as I go through the Act, and I'm still going through it in some detail now, but I'd like to be assured that in a lot of the provision, we take into consideration that we have some profound technological changes. Track and trace, for example. Track and trace don't allow now for any convoy escorting goods across Jamaica. We simply apply the track and trace and get the data and monitor. And that's what track and trace means. So, and all of that has to go towards creating an environment that that we can, in fact, offer the logistics services that we are promoting, or I said we want to promote. And I think in those regards, the definition, the transit, the coasting, I think we need to revisit those and to see how in practical ways technology, which is not technology to come, technology that is present, can be applied to aid the process and address the really reasonable concerns that the customs may have in terms of protecting, goods and revenue. Yeah? So I do believe there's much there that we'd want to look at, but in the interest of time, I'll just stop at that.
Thank you, Member Hilton. Member Malhoufort.
Through you, Chairman, let me first of all indicate thank you for your clear articulation of the concerns that you have with the bill. Your starting point struck me in respect of the uncertainties due to the details that are to come in the prescribed rules and regs. Right. Understood. The customs agency are under clear instructions that the work must be done in a timely fashion because the law cannot be brought into effect. And when the
Let's put it in a positive. You don't want to have anything to worry about with that because we're committing to bring both the law and the regulations into effect at the same time.
Yes.
So the practice in the past of having a law and then 2 years later, you have some regulations that just drop on you. We're going to avoid that, okay? And that's going to mean more work. But we want to bring, just like we did with the BOJ, when we redid the BOJ Act, we brought the new law into force at the same time as the regulations.
Yeah, it's a good idea.
Minister, what we wanted to find out, will we be given an opportunity to comment? Because we're working with this, we've been looking at this. This is not different from what we've been working on from before, but we need the meat. And we would like an opportunity to look at that.
Someone else asked that before, another group, and we gave the commitment that yes, the regulations, we're going to have stakeholder comment on the regulations before we bring them into force.
Thank you.
Minister, through you, just to add that the upside of the prescribed rules and regs, it's really to standardize a lot of the practices and to have them put in written form to ensure that no one is taken by surprise. And the high level of subjectivity that we have heard about in the past, that we reduce, if not eliminate that. So much of what is to come really already exists by way of practice. It's just a matter of putting them in the prescribed forms.
Well, I'll just make one comment on that. I think just to support those objectives, but if those are the objectives, then I want to say that we need to consider very well the procedure for bringing them into effect.
Just to say, Member Hilton, through you, Chairman, that point is well taken and well noted. After all, if the aim is compliance, then the method by which you are notified and the time frame to ensure compliance is going to be critical. And as we have said to other stakeholders who have presented, the aim is to make life easier, not more difficult.
I just have a point with regards to our logistics, is that the points that we have made with regard to logistics, if we are to continue with promoting this as a flagship for our country, the points of making the business easier for logistics has to be looked at. And currently some of the things are not as easy, and we won't go into them because we've laid them out. And the other point,
to speak for the business-friendly Minister of Finance, you won't have a more business-friendly person there, and it is one of his issues that life must be made easier for people who do business.
And Madam AG, I hear that, but we want to see it in black and white. Yeah?
Yes. And one more point is with regards to transshipment, is that the Port of Kingston is a transshipment hub, and we have blocks between certain areas which make it difficult. So you shouldn't be able to, you shouldn't have a block if you're just moving a container a few yards on the quay. And I think that is very important, that, you know, the way it is set up now is transshipment, you have to transship it through the port that it came in, and that really is not how it is internationally, and it puts us at a disadvantage.
One of the things that struck me as I listened to the presentation, I was taken back to my own concern about ensuring that in our design of law and system, we do not design the system as if we're catching the thieves, or as if everyone who has an issue with either the revenue, customs, is a cheat. You know, to strike the right balance and to ensure that we can come away with a more efficient regulatory environment.
But the risk-based approach is how you attempt to achieve that. Yeah, that's what I'm saying. So it's in the act, and I'm saying we simply have to, but to have that as a high principle is good, and that's a starting point. But you now need to ground the specifics in recognition of those facts, so that the point that is made about transshipment and transit, all of those, I think, need to be looked at. And my strong plea is that, to my certain understanding, where the technology has reached today can aid the customs in very many aspects of those legitimate concerns.
Okay, so just as I indicated earlier, when you're talking about the sufferance wharves, that we had we've had your comments, so we've had a chance to read them.
That's a good thing.
That one we're definitely taking on board. And there are others, we won't be able to take all of your comments on board, but there are certainly other things that you have mentioned that, we, are proposing to accommodate. And I'll just go through a few of those. It won't be exhaustive. There are others that we'll have to deliberate when that clause-by-clause process starts. As I mentioned, the regulations, we already said that the regulations, you will have sight of them before they become law. And our aim is to have the new law come into effect at the same time as the new regulations. In terms of, I'm very, very sensitive to, along the point that Member Malahud mentioned, your point about recognizing a shipping business is a 24-hour business. Ships can arrive at any time. This artificial distinction of having certain times of the day when the cost is higher and certain times when the cost is lower, and you don't even know necessarily when your ship is going to arrive because there could be events on the sea that interrupt the normal arrival schedule. So I'm very, I would want that we could reach that ideal where it doesn't matter what time, right? The costs are the same. That, however, is not something that can be addressed in this law. That's something that we would have to negotiate with the persons who represent the workers and so forth, right? The new Customs Act can't legislate that in itself, but it is an ideal toward that I would be committed to, an ideal that we should strive for and work with you to achieve and work with the Customs Agency. And the Customs Agency as an executive agency, but the point that Customs will make, though, is that it's a little, even though I've agreed that is an ideal that we want to achieve, it's an ideal that will take more than the Customs Agency to achieve. Because as you know much better than me, it's not just the Customs officer who meets the ship. You have the health inspectors, and you have persons from other areas of government. So we would need to have an overall approach to this that would require, and if you know anything about that area of life, we would, in Jamaica, we need to have lots of consultations to bring that into existence. But I absolutely agree that that's an ideal that we should strive for. You wanted to say something?
Just to remind you, Minister, that we're already along the way, because on the terminal, they have flexi time, and they've been doing that for many, many years. So a good part of the logistic chain is already in that mode. So we just need to pull the rest of the logistic chain into that area.
Look, I support you in championing that. But in championing it, you have to understand the levers that need to be, right? You have to understand what needs to happen for it to change. And what needs to happen is not just customs, but it's in different areas of government. And we would have to sit down and let people understand that this does not threaten their income or their employment, but this would make Jamaica a more competitive destination, which would increase the number of jobs that we can have. Huh? Yeah, it would increase the pie, which is what we all want. So I definitely think that should be championed, but the bill is not the place for it. Right? With respect to the warehouse facilities, we're prepared that Customs will only request additional infrastructure in cases where the existing ones are inadequate. Right? And that more regulation-wise. Just looking for some of the easier ones. You want to, Commissioner, do you want to just give a sense, or you want to, let me go ahead. Let me just go ahead. With respect to your point on the special economic zones, right? The regulations for the economic zones, those are under development, and those regulations will require consultation, as I mentioned earlier, before they're finalized. The customs procedures, though, relating to import and export of goods fall within the purview of the Commission of Customs. So the fact that it's, SEC is involved does not exclude the Commissioner of Customs entirely. Once you are dealing with import and export of goods, the customs agency becomes involved. And if we didn't have the customs agency involved, you can imagine that that would be a loophole that would injure, the security interests of Jamaica. And you remember, SEZs are not extraterritorial. They are right here in Jamaica, even though we have agreed that certain laws obtain within the boundaries of the SEZ. On your point on auctions, there's no objection to making the information publicly available, even though we have to deal with the privacy issues. So we're going to have to discuss that further in committee about how we achieve your particular objective, while at the same time ensuring that we don't infringe on any of the privacy issues that might arise. With respect to the logistics services, and again, I'm very sympathetic to this point, that if we're to have a logistics business in Jamaica, we want, I'm using my layman's language here, we want goods to be able to arrive at one port and leave through another port, to arrive by air and leave by sea, and for that to kind of be seamless. And the more barriers that we insert, some of the barriers are invisible, we make those possibilities more and more remote. We are definitely sympathetic to that point, and agree with the principle that the procedures ought to be seamless. So we're not contemplating that special permission is required, but we're going to, need to ensure that the requisite security is a part of those processes. So it's a balancing act, right? I mean, for the container to come into Kingston and then leave out of Montego Bay, you're going to have, certain procedures, right? So I'm just saying, in principle, we accept the point of seamlessness. The devil is always in the detail. And in committee, we'll try and unknot some of the things that you pointed out. Go ahead.
I just interject, just to say, I believe, and I think those involved in the industry can say that the technology is so advanced now that I believe we have to look to the technology to aid the process. Otherwise, in a practical way, we'd have to use the law in a very cumbersome way if we don't introduce the technology and recognize. I mean, as I said, track and trace, for example, gives you visibility and tracking. So the security issue, to my mind, is very attenuated with the application of current technology.
Yes. So, and another way in which we can deal with this seamlessness is in the fee structure. And there's an argument that says that the fee structure for transshipment and the fee structure for transit to export there shouldn't be much of a difference. Right? We're open to all of that. I mean, that's, again, beyond the law itself, and that's more kind of policy. But I'm just giving you an indication that we understand that and would be willing to support it. With respect to one of the points you mentioned, though, about the vessel that is less than 24 hours away, that should be treated differently. The counter argument is that the advance manifest is critical to risk assessment. So I think the law is that you have to provide an advance manifest if you are blah, 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 right? And you wanted to make an exemption in instances where am I getting it right? You want to repeat it?
The issue with that is that the current system requires us to do the advance manifest submission 24 hours in advance of vessel arrival. If the vessel is sailing from a port that is in a shorter distance than 24 hours, it becomes a challenge to submit that manifest. I didn't hear that, sorry.
And let's use a practical, the Dominican Republic. It's a short transit.
Right. So you're proposing you'd submit the manifest before, but the minimum period should be when the ship sails. Is that what you're?
Or something of that sort, just to have something fixed that we understand when it is that we're supposed to submit it, and something reasonable and practicable.
Okay. No, I definitely understand the point that if it's the vessel is originating at a place that's less than 24 hours away, then different requirements are required. You know, you have to be thinking in advance. You know, different procedures are required for a short haul than for a long haul, and that if you're representing multiple agents and so on, or agents coming from multiple destinations, it introduces a new if-then statement or if-then procedure. What's your response to that, Customs? Is there, on the specific, not the vessel is at sea, but it is originating from a port that's less than 24 hours?
Well, Minister, as you indicated, it's a question of risk assessment. The mere fact that a vessel is coming from a near port does not reduce its risk. So a vessel that is coming from Haiti or the Dominican Republic is no less risky by the mere fact that it is coming from that port. In fact, if we were to have a blanket treatment just on the basis of near port, then it means that you would in fact create a loophole, an area of weakness. We do not agree that it is impossible for the shipping agents to comply or for the vessel to comply, because in many other countries there is this requirement. And so what would happen is that either the manifest comes in within the time period to allow Customs to do its risk assessment to determine how to treat that vessel and allow that vessel to be efficiently and expeditiously dealt with when it arrives in Jamaica. Or you may have a situation where that vessel may be sitting out at sea waiting for that risk assessment activity to be done, because the risk assessment is critical. We also want to remember that a colleague of mine says that a ship getting on board a vessel is not like flagging down a bus downtown when it is pulling out of the station, as it were. In other words, there would have been quite a bit of advanced planning. And so it's not a case where as soon as it's when the vessel is departing the port that that manifest information becomes available. And so what the legislation is requiring is that the carrier provide that information. And if it is necessary to make amendments, the legislation contemplates and provides that adjustments can be made to the manifest after the vessel has arrived and within a certain time period.
Okay, what would help the committee when we come to deliberating that is just to get precedents from, say, the best ports in the region. What do they do for near port, right? How do they do it? Do they require 24 hours before, or do they have another means of, and I'd like to just be able to compare.
No,
is that reasonable?
Minister, we'll certainly have that.
All right, so that's how we're going to deal with it, okay? On the point of registration, though, I know that things have been done a certain way in the past. You get a letter from the shipper and you are the agent, But we're now moving to a different dispensation, a dispensation that hopefully will introduce efficiencies, that will make things more seamless, will allow for new business processes, and importantly, will allow for added security of our borders. And like in other areas of life, right, we're moving towards greater formalization. We just passed a bill a few months ago where microcredit institutions are required to be registered. For the last 20 years, they were not. But now we have found it necessary for them to be registered. Very different situation, but I just introduced that to say we're not picking on shipping agents. The world is moving in a particular direction, and it is going to be necessary. for registration of shipping agents. And the registration allows for the authorities to have a certain information that is going to be useful to the conduct of their business, and it sets a certain threshold as well for becoming a shipping agent. It's a business with a great responsibility, and remember where we are coming from, right? Just think about the challenges in the Jamaican society that arise from the fact that we are an island with 90 points of entry by sea, and the challenges that we face as a result of all of that. And so we are bringing, we are modernizing and formalizing and adopting standards that exist elsewhere, and that is going to require a registration process. I don't think we can get away from that one.
Just for clarity, sorry, that is going to be registration by the Jamaica Customs Agency?
Yeah, so the customs agency can't make you an agent with Line X, right? It can't. You have to be appointed by Line X in order to be an agent. But in the same way that the Financial Services Commission requires you, if you're selling foreign life insurance in Jamaica, you have to be registered with the FSC to do it. Now, the FSC can't appoint you to be the agent of a life insurance company in New York. But if the New York company wants you to sell their life insurance in Jamaica, under our law, you have to be registered with our regulatory body in order to do so. That's an analogous situation that, yes, you have been appointed by shipping by a line that's from Denmark or the Netherlands or China or wherever, but for you to do the business here in Jamaica, our authorities have to have you registered, and you fill out a form, you provide information, and you are duly registered with the regulatory authority. And in other industries, that's very standard, right?
Chairman, I accept the broad points that you make. I think one of the consideration I would want to have when we come to discuss this in the clause by clause is to understand the government's fundamental concerns and whether it can be done other than I'd want to know how this registration by custom aids the concern, the overriding concern that the government has, because it is not obvious to me that the only way to do this is through a registration under the Act. Best practice in some areas have industry dealing with certain aspect of it and regulating.
No, we can't. We can't. That is totally out of step with other industries in Jamaica.
Chairman. Listen, if we're going to have a debate when it comes, it can't be no, we can't do it. My point is, I need to I've enunciated what my concerns are. I would need to hear from the government what are the concerns, the mischief that is trying to address in requiring this as part of that. I'm not saying there's not a case to be made. I'm just saying I think I'd want to hear that and to hear those concerns and how this particular approach will address those concerns. That's my only point.
No, fair enough. And when we go through clause by clause, we can address it. Suffice to say for now that I was trying to simply provide you with the parallels that there was a time when when you were selling foreign life insurance in Jamaica, you would not need to be registered with FSC. For decades, that was the case. But there came a time when you needed to be registered, and that's the case. That's been now like that for 10 years. There's a time to operate a microcredit industry, microcredit business, you would not need to be registered. Well, the time came when that needed to change. And I'm just giving that as parallels, and there are many other examples. As we seek you can be sure that in advanced economies, I don't need to say any more right now, but what we're doing here is a simple process of modernizing and formalizing. with the requirement of registration. We can discuss it more in committee. Just back to the point on, I just got a note here, just the point on advanced manifest. Can you just tell what happens in the airline industry when people have less than 24 hours? Again, we're not going to settle the issue now, but I just want to ask the question. Or maybe you can get back to, you have the answer?
Minister, there's a minimum.
Can you give us the name, please?
Marlon Lowe, Deputy CEO, Jamaica Customs Agency.
Marlon?
Lowe. There's a minimum requirement for the airline for long haul, minimum 4 hours. For short haul, 15 minutes wheels up.
Okay. So, and these are cargo planes? Any plane. All right. So in committee, what we have to examine that differential and, examine the peculiarities of air and sea and why the difference, and look at precedents, look at some of the more efficient destinations or ports or maritime places in our region, and be guided by, precedent.
In the Chairman, in the case of the airline industry, IATA sets the international standard which most countries apply.
Yeah. Okay. Right. I was just going through. Yes,
Excuse me,
yes, go ahead, please.
I don't want to belabor the point, but I just wanted to put it on record that the Shipping Association does not object to the registration to use a customs system. So to use ASECUDA or whatever customs management system, we do not object to that kind of registration. Where we had a concern was registering us as agents. Okay?
Okay.
So it's not unusual because the registration is insofar as you're transacting with customs. So let's rethink it on both sides, because it's important. The requirements are important for custom transactions and for custom purposes. But I hear and understand the point that has been made. Chairman, we are beyond our 5:30 shift time.
Yes, we are, and I think we have. In terms of the main, there were other points that were raised, but in terms of some of the main ones, I wanted to just give an indication of some preliminary thinking that will be finalized in committee.
A thought on the very first issue that was raised about the dissimilar treatment of the shipping agent with the customs broker in terms of declared agency and
we dealt with that under the previous submission, that what the Act is seeking to do is to define by activity, which gives a lot more flexibility in how the Act is written. So because licensed professionals, whether they, in this case, in the future, licensed meaning registered, whether they be shipping agents or they be customs brokers, can perform a number of functions. What Act seeks to do is to prescribe the rules and the laws around the performance of that activity. So it's dealing with the verbs rather than a noun of who this person is. It may be a little discombobulating to, your customs broker, your shipping agent, and the law doesn't kind of call you by name. That's not sort of unique in other industries. That happens as well. Because we recognize that these professionals can play different roles, the law legislates the activity. And if you are performing this role, whether you are a shipping agent or somebody else, then this is what obtains. Now, the yes, go ahead.
Narrow point that I heard, and I'm having some concern, is about the disclosed agent that then exempts them from certain liabilities, as opposed to, and therefore, and places the liability on the principal, and whether the bond the government can secure its interest by having the bonds or the security kind of arrangement rather than imposing the liability, which on the face of it, seems unfair to the shipping agent who would not be ordinarily the one to make the decision or give the instructions.
Okay, so that, the advice, and obviously there's a lot, this bill has been 2 years, 3 years in the making. The advice, Jamaica's standing competitively in international business rankings is such that if we were to move in that direction, when other countries are not doing that, right, it could negatively affect us. We can discuss it more in committee. There is, we're moving to a regime, Member Hilton, across a number of areas and fields where you are going to be required to know your customer. And if you fail to know your customer, there are risks associated with that. That is in many segments of society, well, with many segments of industry and business, whether it be financial services, accounting, gaming, real estate, etc. And shipping is not going to be much different from that, right? So it's but we can discuss it in more detail. The point has been made. We're not settling on anything right now. The point was to see you in flesh. We have your comments. They're listed here. The next stage is we prepare a big matrix, and it has all of your comments that obtain or that apply to the clauses as we go through, and we'll have an opportunity with the committee to discuss all of these in greater detail.
I would ask if there's any clarification that is necessary while you're going through your deliberation, that we will be more than willing to come back and have conversation. And one of the points that I know you spoke about it, but it's very dear to us, is 270 number 9, about the liability of the shipping agent. And we would ask that that is something that we are very, very passionate about and are concerned about how it is currently proposed. Thank you.
All right. I'm just reading it here. Yes, 9 is subject to 10 and 11, though. So 10 basically says if you do all that you're supposed to do. Yeah? But we can...
But 10 is referring to as a customs broker.
So,
Anna Hamilton, Shipping Association of Jamaica.
Right, you're saying it doesn't name...
We are referring to ourselves as agents for the principals for the cargo coming from overseas.
I understand. Okay, this is something that we can definitely look at to ensure that the same release from liability by compliance with the functions expected of you applies to you as it does to the customs broker. Yeah.
Thank you.
Okay, we are at 5:40, and I want to thank the Shipping Association for Jamaica, and in particular its representatives here today, Anna Hamilton, Cora Sylvester, and others, other reluctant ones, for coming here today. And I know you were last of the presenters, so you had to wait the longest. Thank you for your patience and for sharing your concerns and your suggestions. We'll have a vibrant time in committee as we go through the clauses, and hope that at the end we'll have a better regime than what we have today. So thank you all very much.
And thank you.
Thank you.
So while the Shipping Association sort of make their way out, I'll just move to other sections of the agenda. Having heard the presentations today, under any other business, I would put that we invite for the next meeting. Do we have the list of persons who are invited, or are we moving? Okay. Now, a number of the submissions that we got, members, concerned things to do with levels of fees and duties and duty concessions and so on, which, as you know as well as I do, that is not the province of the act that we're looking at. So I would not propose that the committee, that we move in the direction of hearing those submissions. I mean, in other words, we hear submissions where an oral presentation would aid understanding of the submission. Those submissions are very clear. They want a fee to be X or to be Y. So we don't need them, having them here would not add any clarity. The other sort of written ones where clarity would be aided by having them present would be, I believe, Jamaica Lands, even though they make some of the same points, but Jamaica Lands, the Revenue Appeals Division. What's this one? Is this one substantive one? And I believe there's something, the Chancellor Hall. Well, let me just see something here. So, yeah, we had a submission from the Chancellor Hall Committee, which didn't go clause by clause. It was sort of high level, but it would be good to have them. So we would propose to have those three, if the committee agrees, for the next meeting, and thereafter we would go into the clause by clause, which could begin at the next meeting, because I don't know that these three would necessarily take us long. No. Can we have that agreed by the committee? Okay. The next order of business is to set times for the next meetings. At the last committee meeting, we had set dates for 2 other Thursdays in April. I would like to just add 2 other days just to get them while they're available, if you don't mind. I'd just like to add the Thursdays in April. And hopefully between the what am I saying? We are supposed to meet on the 15th, yes. And then what other day do we have? And we have the 29th. Okay. So if we could add, and just before, because I don't want them to disappear. If we could add the 7th and the 21st, or should we just go 7, 14, 21st and just see how the 7th, the 14th, and the 21st? No, those are Fridays. My apologies. Sorry. It would be the 6th, the 13th, and the 20th.
Indicate that I'm unavailable for the 6th with my unavailability.
For the 6th?
6th, but it doesn't have to affect the scheduling of the meeting.
All right, no, since yourself and Senator Johnson Smith, let's go with the 13th, the 20th, and the 27th. If there's any problems with any of those dates, we would, reserved to sort of shift them or to cancel them, but I just wanted to, as we say in the Jamaican vernacular, to bags them before they disappeared. Yes. Okay. Okay. So the date of next meeting is the 15th of April, which is next week. All right, member Malhu Ford is pointing out the 20th is the Thursday before Labor Day. Labor Day is a Sunday. So members of the committee who are members of Parliament may have other duties. All right, so we just go. The 6th and the... Yes, so we go with the 6th, we go with the 13th, and we go with the 27th.
I ask you to note my apology for no, because I'll be in court.
Sure. 6th, 13th, and 27th of May. Okay, so before we move for adjournment, Member Hilton.
I just want to place on record my thanks to the clerk of the committee who did yeoman work and in fact assured me that she reached out to some of the players in the industry whom I had some concerns about, and in the event they didn't respond, and I'm satisfied that the effort has been made and that they'll have to recognize that we did reach out to them.
And I second your commendations of the clerk as well. Very well organized Joint Select Committee thus far. Thank you very much. So, members of the committee, thank you very much for attending and participating today. Thanks to the Jamaica Customs Agency, the CPC, the Attorney General's Chambers, and the Ministry of Finance, among others, for your participation. I want to move the motion for adjournment, seconded by Member Malhu Ford. See you next week. Have a good evening.
Chairman, it was a productive meeting. Very productive. And we move fast. We will go fast. We will go fast with it.